Is this Mr. Fuller?
Fuller, and then we follow immediately with Clay. And Mr. Kirk has his client here.
Okay. Mr. Wagner. Okay.
All right. Case number 23, CR 142, State of Ohio versus Brandon C. Fuller. You're Brandon C. Fuller appearing there from the jail?
Yes, sir.
All right. Mr. Fuller was indicted on 5 counts of rape yesterday, first-degree felonies. Assistant Prosecuting Attorney King is present, along with Mr. Wagner, who court intends to appoint as counsel for Mr. Fuller here shortly. But before we get to that, Mr. King has a representative of the victim, or the victim been notified of the time, place, and purpose of this hearing, and the right to be heard?
Yes, Your Honor, the victim's mother has received notification and will not be present.
Okay. All right, Mr. Fuller, you are entitled to have an attorney to represent you in this matter, and if you cannot afford to hire one, the court will appoint one for you. And I believe you have filled out a financial disclosure form.
Yes, Your Honor.
All right, is everything on this form correct?
Yes, Your Honor.
All right, the court then will appoint Mr. Wagner, Jacob Wagner, to represent you. Now, Mr. Wagner, have you had an opportunity to see the indictment?
Your Honor, only from what the state has, I've not obviously gone into the depths as far as discovery, but we do waive a reading of the indictment at this point in time.
Okay. And how does your client plead?
Not guilty, sir.
All right. Thank you. The court then will, let's see. We'll set the first pretrial for this case for August the 23rd at 1 p.m. The final pretrial will be September the 6th at 1 p.m. And the trial date will be September the 25th at 8 a.m. All right. Now, state wish to be heard on the matter of bond.
Only was contained in the bond recommendation sheet, Your Honor.
All right, Mr. Wagner, on behalf of the defendant.
Your Honor, obviously I always have this right, so I won't say, but if I see a need to file a bond reduction, I will. Obviously I know the severity of the 5 charges, so we'll just defer to the court at this time.
Well, these are all life without parole, a possible maximum sentence.
That's correct, Your Honor.
All right. All right. The court will set bond in the amount of $250,000 plus your own recognizance, which is your promise to appear, Mr. Fuller, and if you should make the bond, and if you fail to do so, you could be prosecuted for an additional felony. If you were to make bond, you'd be under house arrest. You'd be under pretrial supervision. You'd report to probation departments upon your release once a week for 4 weeks. After that, as it determined, undergo random drug testing, provide phone numbers for home zone employer, have no contact with the alleged victim. If recommended by probation, be evaluated for substance abuse and mental health issues, and if treatment was indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest. All right. Thank you.
Thanks, sir.
All right, who do we have next?
So I play your honor.
Hickok. Yes. Thank you, Chief.
this is case number 23 CR 141, State of Ohio versus Scott Allen Clay. You're Scott Allen Clay there at the jail?
Yes, sir.
All right. Mr. Clay was indicted by the grand jury yesterday on a charge of aggravated trafficking and aggravated possession of fentanyl-related compound first-degree felonies, and also aggravated possession of a fentanyl-related compound fifth-degree felony. The Assistant Prosecuting Attorney Adam King is present. Also present is Mr. Kirk, Dennis Kirk, who represented the defendant, I believe, previously, and the court is going to appoint, assuming that you qualify for counsel, Mr. Clay, I believe. Mr. Kirk, you were appointed in the municipal court?
I believe I did have him in
Yeah.
municipal court.
All right. I don't have a financial disclosure form. Have you filled out a financial disclosure form yet, Mr. Clay?
No, sir.
Pardon me?
I've got one.
All right. Well, you need to go ahead and fill that out, and the officer there will fax it up then to us. But are you employed, Mr. Clay?
No, sir.
All right. Do you have any funds with which to hire counsel?
My family hired a lawyer.
Your family is going to hire an attorney for you?
They hired Caleb Johnson from Chillicothe.
Caleb Johnson, okay. Have you been in touch with him?
Not recently. My son does.
Okay, well, have you told him you've been indicted?
Yeah.
Okay, well, he hasn't entered appearance here yet. So, I'll go ahead and, I'm going to go ahead and appoint Mr. Kirk for the purposes of this hearing only, for the arraignment only. And you're familiar with the charges from the municipal court, Mr. Kirk?
Yes, and I did review the indictment that the state
All right,
had.
you wish to have the indictment read?
Would waive reading of the indictment.
All right, and you wish to enter a plea of not guilty on behalf of Mr. Clay?
Yes, Your Honor.
All right. All right, Mr. Clay, if Mr. Johnson's going to represent you, you need to get word to him to enter an appearance in this case so we can notify him of the scheduling order here. But for purposes of today, Mr. Kirk's your attorney, but if you're not able to hire an attorney, because usually when an attorney's been employed, they notify the court that they have been employed. So get a hold of him and let him know. All right, I'm going to set your first pretrial for August the 16th at 1:00 p.m. The final pretrial will be August the 23rd at 1:00 p.m. Trial date will be September 11 at 8 a.m. All right, the state wishes to be heard on the matter of bond.
Only was contained in the bond recommendation sheet, Your Honor.
All right, Mr. Kirk.
I understand that there are 2 felony ones here, so we would just ask the court to set an appropriate bond. And then if we become aware of more information, we can certainly file a motion at that time.
All right, well, both counts 1 and 2 both carry mandatory prison term. Defendant has served a previous prison term, I see, for failure to comply. Or actually not for failure to comply, it looks like no, I can't tell. It was sent to Orient in 2000, March of 2000.
Voluntary manslaughter.
Involuntary manslaughter. Okay. All right, the court will set bond in the amount of $25,000 plus a service fee of $171 prior to release. If you make bond, you'll be under pretrial supervision of the probation department. You'll report to them immediately upon your release. If you do make the bond, just report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing they may order. Have no contact with co-defendant Isaac Garrison. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatments indicated, you'll enroll in and follow that during the pendency of this action, and you'll also be under house arrest at your residence. All right. Thank you. Is that the last one from the jail?
Yes, Your Honor.
Okay. All right, thank you. Early.
I do not.
All right. Yeah. People think that a court that starts early doesn't exist. You're wrong. Yeah. All right. That's case number 23 CR 80, State of Ohio versus Taylor L. Deitch. Is that how you pronounce that, Deitch?
Yes.
All right. Present for the state is the Assistant Prosecuting Attorney Adam King. Present on behalf of the defendant is Attorney Dennis Kirk. Ms. Deitch entered a plea of guilty to aggravated possession of methamphetamine, a third-degree felony. The matter was referred for a pre-sentence report. I have received that and reviewed the same of each of the attorneys received a summary.
State has, Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. I would note that when the defendant committed the offense in this case, she was on community control out of Hamilton County for a felony 3 obstructing justice conviction. She actually had a capias out of Hamilton County at the time she committed the instant offense. In reviewing the PSI, I was a little surprised. Under the section where it says institutional and/or supervision adjustment, there's mention of that Hamilton County case that she was on community control on, and it says that on January 13th, she completed supervision after successfully completing River City CBCF. However, I have the entry pulled up on my phone, which indicates that she was actually terminated from community control unsuccessfully. And like I said, she had a capias out at the time she committed this offense, which was in December of 22. In January of 23, terminated unsuccessfully. And looking at the case history there from Hamilton County, there were multiple community control violations. She was never sentenced to prison for any of those violations. She also was convicted of a felony 5 possession of drugs in Hamilton County while on 3 obstructing. In that case, she was sentenced to 54 days in jail with 54 days of credit. Somehow, despite being unsuccessfully terminated in Hamilton County on January 13th of 23, she managed to get placed on intervention in lieu of conviction out of Warren County on just 1 week later on January 20th. I'm not sure at this point how she's been doing in the intervention in lieu program there, but I just feel like when you look at this defendant's history, she has a long history of being given chance after chance after chance, chance after chance after chance, doesn't appear to take advantage of those chances, instead continues to commit felonies. So based upon that, it's the state's position this defendant is not amenable to community control and would ask that she be sentenced to a term of incarceration. Thank you.
Mr. Kane or Mr. Kirk?
Thank you, Your Honor. My client's actually has probation out of Claremont County rather than Warren County, and she went through STAR there after the Hamilton County case and successfully did complete that. All reports from Claremont County appear to be that she's doing well. Originally, she wanted me to ask this court for drug court, and was very interested in that. However, because she's living in Hamilton County, she's outside the radius that the court can operate in, so we're not able to do that. She is doing very well right now. She's in the block ministry program in Hamilton County. They have been working very closely with her, and looking at the PSI, very big drug history, but it looks like in 2022, things started to take a turn for the better in terms of usage, and I think the block program has done really well for her. She did complete the STAR program and then went straight into the block program. She's still in the block program, and as I noted, is doing well there. And the probation department treatment coordinator did send a letter to the court about the drug court issue, obviously, and she noted in there that it does seem that she's on the right path to be successful with community control. And I think because she's gotten off the drugs and kind of got into a better rhythm here, she's doing much better. And I understand the court will have some concerns, but if the court could give her one chance to demonstrate that she's doing well and will continue to do well, she would ask the court to grant community control and any appropriate treatment. Thank you.
Good, thank you. All right, Ms. Deitch, anything you'd like to say?
I have been stuck in a vicious cycle of addiction since I was young, and I'm trying my hardest to break that cycle. I do have an extensive record, and honestly, like prison, I just know it's not going to help me. It's just going to make me worse, and I'm doing so good at the program I'm in right now. Like, I've got a good support network around me. I was just baptized Sunday. I've got a sponsor who I'm with all the time, and I'm really trying to break the cycle before I end up in prison or end up dead before I'm 30. And I don't want to live that lifestyle anymore.
Well, yeah, it does appear that you've had a fairly extensive record for a person your age. And unfortunately, some of our bigger counties like Montgomery and Hamilton, they kind of just let people go and go and go and never really hold them accountable. And instead of punishing you for your failures, they just say, okay, we're done, you're done, it's unsuccessful. And we don't do that here. If you don't comply, you're held accountable. Based upon your history, you know, I have some concerns that you're going to be successful, but you have been you did complete the STAR program, and you have been in the block program since June and are doing well. And so, based upon that, I am going to give you one chance, and that's going to be one chance. So remember, one, because you've had a whole bunch of other chances from other courts, and had those been here, you'd already had time in, at least one number, and looking at the way you were going, maybe two. But you're going to get this chance.
Thank you.
So the court is ordering that you be put under 3 years of community control supervision of the probation department under these terms. You must obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, you must report when and as directed, you must be truthful in all statements you make to the probation department regarding your conditions. You must keep them informed of your residence and place of employment at all times, may not change either without prior permission, may not leave the state of Ohio at any time without prior written permission, may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior permission. Now, because of your conviction in this and in the other cases, you're disqualified under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. And if you do so, you could be subject to prosecution for both federal and state charges. It's also a condition of your community control that you not have any of those items while you're under supervision, nor any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription. You must provide a copy of that within 24 hours of receipt to the supervising officer. Medical marijuana is not permitted. It's not a prescription, it's an order, and it is not permitted for you to have a medical marijuana card. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. You may not associate with anyone who's a co-defendant in this case or any other person who has a record, member of a criminal gang, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer that applies to any family members that would fall within that definition other than those with whom you were residing immediately prior to the commission of this offense. After the date of this order, you may not marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement, any arrest, citation, conviction, or other charge of violating the law, not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you are referred by the probation department for an evaluation or assessment for any other type of programming, other than that ordered by the court, you shall submit to that, and if there's any recommendation for programming, you're to enroll in and successfully complete that. You're to pay the court costs of this action and make payment arrangements with the clerk to do that. You'll be required to successfully complete the block ministry's substance use disorder treatment and aftercare. Now, by being placed on community control rather than being put in prison, you're deemed to have consented to a search without a warrant of your person, your vehicles, your residence, or any place or property that's under your control where you're found at any time by any officer of the probation department. You're to sign a consent acknowledging that at the probation department. There will be no fine or any suspension of your driving privileges. Now, you're ordered to pay the court costs and make payment arrangements as a condition. That's also a substantive order. If you don't make your payments, the clerk can collect that through various means, including levying on bank accounts, wages, and other earnings or assets you may have. If that doesn't collect it, the court could order you to do community service and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied, they will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then the court can sentence you, can revoke your community control, and then sentence you to a term of imprisonment of between 9 and 36 months as provided by law, and fine you $10,000. If that happens upon completion of the prison term, the law provides that the adult parole authority may, at their option, place you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised by a parole officer under those terms they set. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you committed a felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, so that will complete the case. You're not under pretrial supervision any longer, but you'll report to the probation department. You'll have probation on. Oh, you want her to see you, or okay? See Ms. Sturgill over here. Now, again, I'm telling you, you get one chance, and you're not going to be treated the way you were in Hamilton County. That's not the way we operate up here. Because if you don't make people accountable, they don't succeed. Right. And so if they're not going to supervise you and hold you accountable, then why even have the case? So if you come back in here, and are found to have violated the probation conditions that I've imposed upon you, there's a fairly high likelihood you will go to prison. So you need to understand, you're going to be held accountable here.
Yes,
all right. Anything further, counsel?
No, Your Honor.
All right. All right. You can see Ms. Sturgill. Thank you.
Thank
all right.
you.
James Paul.
Recording stopped.
All right, this is case number 23 CR 86, State of Ohio versus James Richard Pauley. I have a case here in court, and I'll be with Ms. Rich here in just a few minutes. Appearing on behalf of the state, Assistant Prosecutor Adam King. Appearing on behalf of the defendant, Attorney Sarah Barger. Are you James Richard Pauley?
Yes.
All right, Mr. Pauley has entered a plea of guilty to aggravated possession of methamphetamine, a 5th-degree felony. The matter was referred to the probation department for a pre-sentence report, which I have received and reviewed, and have each of the attorneys received a summary?
State has, Your Honor.
Yes, Your Honor.
All right, Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Barger?
Just what is contained in the plea agreement, Your Honor.
Mr. Pauley, anything you'd like to say?
No, sir.
All right, now you have filled out a request for admission into the drug court docket, and I have a report from Ms. Sturgill that you've been screened, and it appears that you do meet the clinical criteria and are therefore eligible. Now, under the law, I don't order people into the drug court. They have to request to be admitted into that docket because it is a more intensive, comprehensive supervision plan and program. Quite honestly, it's harder than regular community control, but there's a reason for it because we have better success with it. But it has to be something you want to do. You don't go into the drug court program simply to try to stay out of prison because that doesn't give you any more breaks than just being on the regular. But the focus of the drug court program is to focus on your sobriety, recovery, and rebuilding your life. And so there are a lot more resources available to you, but there's a much bigger commitment on your part. And if you're committed to being sober, then, and you do maintain your sobriety, then it's highly unlikely you're going to commit any more crimes. On the other hand, if you're just trying to stay out of prison for a couple of years until you can get off paper, you're not going to change your life, and you'll be back. And you may not even make it on community control. You may end up in prison anyway because of that. So that is your decision. Now you did file the application. Is this what you want to do?
Yes, sir.
Okay. Then the court then will approve your application and admit you into the drug court docket. And it's ordered that you be put under community control for a period of 3 years in the drug court docket. And you're ordered to comply with all of the requirements and conditions that are set forth in the program description, which you were given and they went over with you, and the attachments that were provided. Those have been filed with the court as well. I'm going to highlight some of those conditions, but you're required to comply with all of them. And those conditions do include obeying all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, reporting when and as directed, being truthful in all statements you make to the probation department, all answers you give to them when they ask you questions. You're required to keep them informed of your residence, place of employment at all times, may not change either without prior permission. Do not leave the state of Ohio at any time without prior written permission. You must have a copy of that with you when you go out of the state. You're not permitted to enter upon the grounds of any correctional facility nor to communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. You're not permitted, because of your conviction, to purchase, possess, own, use, or have a firearm, ammunition, or dangerous ordinance under your control. To do so would be a violation of both federal and state law, subjecting you to additional criminal prosecutions. It's also a condition you not have any of those items or any other weapons of any type while you're on community control. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD, or kratom, or any variant or analog of any controlled substance or drug of abuse that has effects similar to those, nor may you possess have under your control any instrument, device, or thing that may be used to administer drugs or prepare them for use administration, except for those for which you have a lawful prescription. And you must provide a copy of the prescription for the instrument or device as well as the controlled substance drug of abuse within 24 hours of receipt. You're to submit to drug testing when and as directed, and that'll be pretty intensive. You'll be calling in every day and being tested at least initially probably 2 to 3 times a week, sometimes more, sometimes less. And you're not permitted to obtain a medical marijuana card while on the drug court docket. Even though that's lawful, you can't have it. It's just like getting a prescription is lawful, but again, you're going to have to comply with the drug court conditions about that, with informing the doctors of your being in the program and having them sign acknowledgement that you told them and that type of thing. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage or any other, nor may be present with it sold or being consumed, even as otherwise lawful. And even though that's not your issue here, what we find is that people with addiction and dependency, if they're not using their drug of choice, they find other things. That's why we don't allow medical marijuana cards. That's why we don't let you drink alcohol, even though it's legal. You're not permitted to associate with any co-defendant, I don't think there were any, or any other person who has a record as a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless approved in writing by your supervising officer. You may not, after the date of this order, marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must you must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you are referred by the probation department or any member of the treatment team for further evaluation or assessment for further type of programming, then you're to submit to that. And if they recommend that you undergo that program, then you'll be required to enroll in and successfully complete that. You'll pay the court costs of this action, make payment arrangements with the clerk to do that. And again, you're required all other conditions that I haven't specifically mentioned in the drug court program description that you've been provided. And you're to comply with your treatment plan as recommended. Now again, treatment plan you're in, you're not in custody, and sometimes they'll say, okay, here's what we would like you to do, and then they'll say, but we can't make you do it, and then you say, well, then I'm not going to do it. Well, if you were just a regular patient, that would be fine, but in this program, if they say you should do it, then the answer is yes, I'll do it. Not that I don't want to do it, or not that I think I don't have to do it. They say you should do it, we're trusting their judgment, not yours, because your judgment's got you here.
Yeah.
And that's why we substitute others' judgments for yours while you're in this program. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed that's under your control where you're found at any time by any officer of the probation department, and you'll sign a written consent form acknowledging and permitting that. There will be no fine. There will be no driving suspension. Now, you're also ordered to pay the court costs as a substantive order. It's required you make payments as a condition of your community control, but if you don't make those payments in a timely manner, the clerk can collect those through other means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work, and an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you're not complying with the program requirements, then they will they can impose sanctions for some things without court action, but if they feel that it's necessary, then they will file a written notice of that with the court, give you a copy. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can terminate you from the drug court docket, revoke your community control, and sentence you to prison for a period of 6 to 12 months and fine you $2,500. If that occurs, then the law provides that upon completion of that prison term, the adult parole authority, as part of the sentence, could put you under post-release control supervision for a period of up to 2 years, which means you'd be supervised on the terms they set by a parole officer, and if they determine that you failed to comply, they could return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony while you're under post-release control in this case, then in addition, whatever sentence can be imposed by the judge in the new case, the judge could also sentence you for committing that violation while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. All right, now that completes the case. You're no longer under pretrial supervision or house arrest or under the new conditions. You see Ms. Sturgill over here. She'll make arrangements for, tell you when you need to report for the new program. And I think the next drug court session is a week from Friday, so we'll expect to see you then. Anything further from council?
No, Your Honor.
No, Your Honor.
All right, thank you. All right, this is case number 23 CR 022, State of Ohio versus Avalon Rich. And are you Avalon Rich appearing there from the TRC screen number?
Yes.
All right. Ms. Rich's attorney is Sarah Bargers. This hearing is being conducted by Zoom. Ms. Bargers appearing on her phone, appearing from the prosecutor's office, Assistant Prosecutor King. The defendant was convicted of 2 counts of receiving stolen property by her plea of guilty, both 4th-degree felonies. The court ordered a pre-sentence report, which I have received and reviewed. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. And Ms. Barger, do you and your client both agree that this matter can be conducted remotely by Zoom rather than her making a personal appearance before the court?
Yes, Your Honor.
And are you in agreement with that, Ms. Rich?
Yes.
All right. Now, if you should need to talk with the attorney at any time during this proceeding, Ms. Rich, just tell me, and I can put the 2 of you into a breakout room where it'll be just you and her talking, and no one else will be able to see you or hear you, okay?
Okay, thank you, Your Honor.
All right. All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor, and there is no restitution.
All right, thank you. I was going to ask you that because there was nothing in the report about it. All right, Ms. Barger, on behalf of the defendant.
Just what is contained in the plea agreement, Your Honor.
Ms. Rich, is there anything you would like to say?
No, Your Honor.
All right. Well, it's the order of court, Ms. Rich, that you be placed under community control supervision under the supervision of the probation department for a period of 3 years under these conditions. You must obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, must report when and as directed. You must keep your supervising officer informed of your residence and place of employment at all times, may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, own, use, or have under your control a firearm, ammunition, or dangerous ordinance weapon of any other type. You may not purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any other variant or analog of a controlled substance that has effects similar to those. Nor may you have any instrument, device, or thing that may be used to administer drugs or prepare their administration unless you have a lawful prescription for both the device or equipment or instrument as well as the substance. And you provide a copy of that must provide a copy of that within 24 hours of receipt. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have in your control any alcoholic beverage, nor may be present in places where they're sold, being consumed, even as otherwise lawful. You are not to associate with anyone who's a co-defendant in this case, specifically Mr. Harner, nor any other person who is a member of a gang or any criminal group or has a criminal record, or a person who could or has in the past influenced you to commit a violation of a criminal code or to violate these conditions. And that applies to any family members that may fall within that definition unless you were living with them immediately before the commission of these offenses. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another person without prior written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for an evaluation assessment for any kind of programming beyond that ordered by the court, you'll submit to that. If there's any recommendation for programming, you're to roll in and follow that during the pendency of this action. You're to pay the court costs and make payment arrangements to do that. You'll be required to perform 400 hours community service at the rate of 20 hours per week for 20 consecutive weeks unless you're employed at least 20 hours a week, a full-time student, or you have documentation by a physician or prior disability finding you're physically unable to do that. You'll be required to comply with the successfully complete the TRC substance use disorder program and aftercare. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, vehicles, or residence, or any property or place where you're found is under your control at any time, any officer of the probation department, and you have to sign a written consent to that. Now, in the event that you fail to pay the court costs as ordered, the court could then order you to do additional community service beyond that already ordered by the court and give you credit for each hour you worked, and then already accepted by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with the conditions imposed in this order, then the probation department will file a written notice out with the court and give you a copy. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is you fail to comply, then at that time the court can revoke your community control and sentence you to a period of incarceration of between 6 and 36 months and fine you $10,000. If that happens, once you complete the prison term, the adult parole authority may decide under the law to put you under post-release control supervision for a period of up to 2 years, which means you'll be supervised on the terms they set by a parole officer. And if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, but there's a cap or limit of half of whatever the prison term was for all violations. But if you are convicted of a new felony while under post-release control, in this case, then in addition, whatever sentence can be imposed by the judge in the new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, Ms. Rich, this completes your case. You're no longer under pretrial supervision requirements, but you will be under the supervision of the probation department. So you'll need to contact them, let them know that you were sentenced today, so they can make arrangements to transfer you to the felony department. All right? Thank you.
Thank you, Your Honor.
All right. Are you Zachary McGraw appearing there from the probation department?
Yes, sir.
All right, this is case number 22 CR 237, State of Ohio versus Zachary Thomas McGraw. Mr. McGraw is appearing by video from the probation department, and his attorney is Catherine Hapner. This hearing is being conducted by Zoom. She's appearing from her office, and appearing from the prosecutor's office is Prosecutor Collins. Now, this matter was set for a hearing on an intervention in lieu of conviction plea, but I don't have a plea form, nor do I see anything in the report from any treatment facility. What's the situation?
Have the questions been filed?
Yeah, that's what resulted in the, I believe, resulted in the case being, yeah, that was filed on June the 8th. That's why we ordered the evaluation. And I've got the report, but there's nothing in there. Well, there's no documentation that he's in any kind of a treatment program. Mr. McGraw, are you in a treatment program now?
Yes, over behind Frisch's at the FRS. I go the 7th of this month for a evaluation.
So you're not in a program then? All right. You're going to the 7th as your evaluation?
Yeah.
All right. We'll need to reschedule this then.
Okay.
So, let's see. Continue this until, let's see, August 24th, Ms. Hapner, I think you may not be available that day, if I recall.
Yeah, we would have to do it early in the morning. I've got Washington Cross Municipal, and then I've got some other things early that morning on Zoom. If we did it before those.
We had Timothy Williams, isn't that your client?
Yes, that's what I'm saying. I have some things that morning. So if we
Okay.
could do this
What time is that set for?
9.
All right, let's set this at 9:15 then, on August the 7th. And we'll do that by Zoom. So Mr. McGraw, you'll go to the probation department. And you'll need to make sure that you sign a release with that information for the probation department to get that, and for that to be sent up to the court.
So I'll come back August 7th?
August the 24th at 9:15. Your assessment's the 7th.
Yes, sir.
So, and then you'll need to get in touch with your attorney because there's not a plea form signed, is there?
No, you'll need to get that. You'll need to come over here and get that signed too.
Yeah, okay. So once you get your evaluation, then you go get a hold of your attorney to go over and look over the paperwork to sign that, okay?
Okay, sir.
All right, thank you.
Thank you.
All right. All right, State of Ohio versus Kimberly R. Hickok, 20 CR 108. You're Kimberly Hickok appearing there from the jail?
Yes.
All right, this is a hearing being conducted by Zoom. Ms. Hickok's attorney is Catherine, let's see. Are you? No.
It's Miss Witt, Judge.
Yes, Danielle Witt, okay. Danielle Witt, who is appearing from her office by Zoom, appearing on behalf of the state's prosecuting attorney Collins. Appearing on behalf of the probation department and drug court docket is John Parr, probation officer. Ms. Sturgill is also present, drug court coordinator. The defendant was placed on community control and admitted into the drug court docket on September the 3rd, 2020, on a charge of receiving stolen property, a 4-3 felony. There was a notification filed of alleged violations on July the 26th. Ms. Hickok was informed of the allegations, and court appointed Ms. Witt to represent her. Now, Ms. Witt, do you and your client both agree this matter can be conducted by Zoom rather than an in-person court hearing?
Yes, we do, Your Honor.
All right, and you're all right with that, Ms. Hickok?
Yes, Your Honor.
All right. Now, Ms. Collins, has the victim of this offense been notified of the time, place, and purpose of this hearing, the opportunity to be heard?
He has, Your Honor.
Are they present?
No.
Okay, all right. Now, Ms. Witt, you had opportunity to review the allegations with your client?
Yes, I have.
All right, do you wish to have a hearing on this, or will there be an admission?
No, she does wish to admit to them.
Okay. The allegation that was filed, Ms. Hickok, alleges that you have violated Rule 2 on 4 separate counts. Alleges on or after 12/14/21 you failed to report. On or after 12/16/21 you failed to report. On or after 12/17/21 you failed to report. And on or after 12/22/21 you failed to report. Rule 7 alleges on or before 7/26/23 you used methamphetamine and amphetamine. And in Rule 13, on or after 12/9/21 you failed to complete an assessment for outpatient at Family Recovery Services. And then Rule 18, that on or about 12/22/21 you failed to show for drug court. Now, those were the allegations filed against you. You recall those?
Yes, Your Honor.
And you understand those allegations?
Yes, Your Honor.
And you understand you have a right to have a hearing in this matter in which the state would have to present testimony that would prove to the court that you have failed to comply with those conditions?
Yes, Your Honor.
All right. And you understand you have a right to have your attorney cross-examine those witnesses and to produce testimony and evidence on your behalf, if you have any, to contest the allegations. You understand that?
Yes, Your Honor.
Right now, in the event that you admit to these violations, one of 3 things can happen. I could continue your community control under the same conditions previously ordered. I could continue it with additional conditions I think are appropriate, or the most serious is I can revoke your community control and sentence you to prison for up to 18 months and fine you $5,000. You understand that?
Yes, Your Honor.
Has anyone threatened you in any way to get you to make these admissions?
No, sir.
Has anyone promised you anything if you admit to the violations?
No, Your Honor.
All right. Do you have any questions at all about the matter?
No, sir.
All right. Then is it your decision to admit the violations?
Yes, Your Honor.
All right. Anything from the state regarding disposition?
Your Honor, the state is requesting that the defendant's community control be revoked and that she be sentenced to a term of incarceration. The state would note a couple of things. This is actually not her first violation, and on July the 21st of 21, when the court continued her on community control and drug court, the court advised her at that point that that was her last chance, and that if she did not complete drug court in community control, that she would be sentenced to prison. She is obviously not only not completed, but she hasn't been seen in about 2 years. Additionally, we would note, while this is not part of her probation violations or community control violations, she has only made one payment of $25 to try to make this victim whole. She owes still $458.81. I've spoken with this victim, and he's obviously still waiting for his money. And finally, I have spoken with Ms. Sturgill, and they really just had it with her. She has not taken advantage of any of the opportunities that they have provided for her, and they are just not willing to look for even another treatment facility. She's clearly not interested in changing her life and taking advantage of the many opportunities that she's been given, and any further use of community control and drug court is a waste of resources that others could use and take advantage of. So we are asking that she be sentenced to prison at this point.
Hey, Ms. Witt?
Yes, Your Honor. And speaking with Kimberly, she does realize that prison is likely here. However, would like to still ask the court for consideration for drug court. But regardless of today's outcome and the court's decision, and speaking with her, she stated it is her intention to seek treatment once her consequence is finished. So we just asked the court for, although it'd be a long shot, a shot at community control again and drug court, and that's about it.
All right. Ms. Hickok, is there anything you would like to say?
No, sir.
All right. Well, we had a lot of conversations while you were in drug court, and you absconded back in December. I signed a warrant for your arrest, or an entry to order your arrest on December 27th. It was filed of 2021. So it's clear that you decided that you weren't going to do the things that needed to be done to change your life, and that's your choice. I mean, again, I understand objection, but you had a lot of other issues too, and then you just simply weren't complying, which is why I told you the last time that that was your last chance. So it's the order of the judgment of the court that you be and are hereby sentenced to the Ohio State Reformatory for Women at Marysville, Ohio, for a period of 15 months. Did you do STAR program?
Yes, I did.
Okay. You'll be given credit for jail time of 46 days, and Mr. Parr, do you know how many days she did in the STAR program?
Back real quick here.
Do you know how many days it was, Miss Hickok?
I was there 133 days from 7/28 to 12/4.
Okay. Of 21?
Yes, sir.
All right. Subject to Mr. Parr confirming that, you'll be given that credit as a well, so that would be 172 days of jail time credit. Now, upon completion of the sentence, Miss Hickok, the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised in the terms they set by a parole officer. And if they determine that you have failed to comply, then they can return you to prison to make you serve an additional period of up to half of this prison term, which is 7.5 months for one or more violations. But if you commit a new felony, then in addition, whatever sentence the judge in the new case could impose upon you, the judge could also sentence you to an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. You're also ordered to pay the court cost, for which judgment, grant, and execution is ordered. If you don't do that, upon completion of your prison term, not while you're in prison, but once you get out, you could do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. You're also still under the order to make restitution under the original sentencing order, and that will continue even after you've served your time. Now, also, Ms. Hickok, I will tell you that I think that as soon as you walk in the door, they hand everybody a proposed motion for judicial release as part of their welcoming packet. Don't file that because you're not going to get it. If you do file it, I can't stop you from filing it. I'm just telling you it's a waste of time. If you file it, it's going to be denied as soon as I see it, because I don't give judicial release to people that have had as many problems as you've had with community control and had it revoked. It's just not going to happen. So that's just to tell you that you might as well save your time and effort. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. Ms. Witt, if you would remain on, please. We have to do a couple of quick arraignments here, and then we'll do Mr. Taylor. So, officer, if you could bring in Mr. Bailey.
Bailey?
Yeah, David Bailey, and then Derek Eisen after that, and then Robert Taylor. All right, are you David Bailey appearing there from the jail?
Yeah, yes, sir.
Case number, okay, this is case number 23 CR 148, State of Ohio versus David Bailey. Mr. Bailey was indicted by the grand jury yesterday on a charge of breaking and entering, which allegedly occurred in this county on or about May 16 of 2023, an empty house on Prospect Road with purpose to commit a theft. And in count 2 alleges that he, on or about that same day, he committed a theft against owners identified as V1 and V2. Count 1 is a 5th degree felony breaking and entering. Count 2 is a theft and misdemeanor. Mr. Bailey, you're entitled to have counsel in this matter, and if you can't afford to hire counsel, the court will appoint one for you. And I saw you filled out a financial statement, and I know you're awaiting transport to prison, so everything on this is correct?
Yes, sir.
All right, well, the court appoints Ms. Danielle Witt to represent you, and she is present for this hearing. Ms. Witt, you're aware of the indictment?
Yes, Your Honor.
All right, and do you wish to, how do you wish to plead on behalf of your defense of your client?
He enters a plea of not guilty.
All right. All right, the court then will set a, I know you're going to be transported to prison. I don't know if it's going to be this week or next week.
No, Your Honor, I'm here.
Oh, that's right. I'm sorry. You're actually, yeah, you're actually on a jail sentence. That's right. I forgot. All right. So, the first pretrial will be set for August the 23rd at 1 p.m. Final pretrial will be September the 27th at 1 p.m. And your trial will be set for October the 10th at 8 a.m. Now, I neglected to ask, Ms. Collins, has the alleged victim of these counts been notified of the time, place, and purpose of this hearing, the right to be heard?
Both victims have been notified, Your Honor, and of the hearings, and they have both said they will not be in attendance today.
All right, thank you. All right, you wish to be heard on the matter of bond?
Your Honor, we are requesting a $2,500 bond based primarily on the violations, as well as Mr. Bailey had I believe this might be what he's serving time for now. He had a failure to appear warrant out of Hillsborough Municipal Court. So he has a history of failing to appear for court hearings. So based on that, we are asking for a $2,500 bond. Thank you.
Ms. Witt?
Yes, Your Honor. I don't have a lot of knowledge about the case or his violations. However, have represented him before, so know he does have ties to the community. So I do ask the court for an OR bond.
All right, it's your the court that bond be set in the amount of $2,500 plus your own recognizance, which is your promise to appear. Mr. Bailey, if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced no matter what happens in this case. You'll also, if you make bond, you'll be under pretrial supervision and probation department at 117 East Main Street. Report there immediately after release. Must report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing, provide phone numbers for home cell employer, have no contact with alleged victims if recommended by probation, be evaluated for substance abuse and or mental health issues. When treatment's indicated, you enroll in and follow that. During the pendency of this action, you'll be under house arrest at your residence at 513 West Main Street. All right, thank you. All right, next case would be Mr. Eisen.
I guess.
All right, are you Derek Eisen, Senior?
Yes, sir.
All right. This is case number 23 CR 149, State of Ohio versus Derek Eisen, Senior. Mr. Eisen's appearing by video from the jail. The Defendant was indicted for domestic violence on August the 1st, and the state is represented by Prosecuting Attorney Collins. And Ms. Collins, has the alleged victim of this offense been notified of the time, place, purpose of this hearing, and the right to be heard?
She has, Your Honor, and will not be attending.
All right. Now, Mr. Eisen, you're entitled to have counsel to represent you in this matter, and if you can't afford it, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on this form correct?
Yes, sir.
When was the last time you were employed?
It's been quite a few years.
All right. Court appoints Attorney Danielle Witt of Hillsborough, Ohio, to represent you. Ms. Witt is present for this Zoom hearing from other cases. The offense alleged is domestic violence, which allegedly occurred on July the 7th of 2023, and is a third-degree felony because of the alleged two prior domestic violence convictions. Now, Ms. Witt, do you waive the reading of the indictment?
Yes, we do, Your Honor.
And what is the plea?
A plea of not guilty.
All right. The let's see here. Oh, there we go. All right. The court will set the first pre-trial in this matter for August the 23rd at 1 p.m. The final pre-trial will be set for September 27th at 1 p.m. The trial will be set for October 10 at 8 a.m. All right. Ms. Collins, on behalf of the state, do you wish to be heard on the bond?
Your Honor, we are requesting a $10,000 bond. Would note that this is an offense of violence and is a felony of the third degree based on the defendant's prior convictions for domestic violence. Would also note that he has been charged with failure to appear in the past for failing to appear at different hearings. He has served prior prison sentences, has a lengthy criminal history in Highland County, as well as a criminal conviction out of Kentucky that also resulted in a probation violation. Based on the nature of the charge, the fact that this is a violent offense, and the danger that he posed to the public, we are asking for a $10,000 bond. Thank you.
Ms. Witt, anything you'd like to say?
We just asked the court for a lower bond or an OR bond.
All right. Well, I'm looking at the Ohio Court Network report that we have in all bond matters, and note the previous convictions as alleged in the complaint. There has been also convictions out of Clinton County for possession of drugs and illegal manufacture out of this court. And a domestic violence conviction again in 2019. I also will note there have been arrest warrants issued in the past for failure to appear, violation of protection orders, and therefore the court feels that Mr. Eisen would pose a significant risk to the alleged victim. So the court's going to set bond the amount of $25,000 plus OR, which is your promise to appear. If you make that bond and you fail to appear, then you could be prosecuted for additional felony. You'll also be under pretrial supervision probation department. Make bond, report to them upon release. Report to them once a week for 4 weeks. After that, as they determine, to go random drug testing. Provide phone numbers for home cell employer. Have no contact with the alleged victim. Recommended by probation, be evaluated for substance abuse, mental health issues, may treatments indicated, roll in and follow that during the pendency of this action, and also be under house arrest during the pendency of this action. All right, thank you. Robert Taylor will be next. All right, this is case number 23 CR 81, State of Ohio versus Robert Keith Taylor. You're Robert Keith Taylor appearing there from the jail?
Yes, sir.
All right, Mr. Taylor's attorney is Catherine Hapner, appearing from her office. This hearing is being conducted by Zoom. Appearing on behalf of the state is Prosecuting Attorney Collins. Now, the purpose of this hearing is a motion to quash or to modify a subpoena filed on behalf of a Candy Moore. And that was filed on July 24th on her behalf by her counsel, Devin, is it Flayhive?
Yes, Judge, Flayhive.
All right. And Ms. Flayhive is appearing as well by Zoom. All right. Now, Ms. Flayhive, you have anything you would like to add to the memorandum that you filed in this case?
Sure, Judge. I'm also happy to recap a couple of the relevant facts, if that would be helpful to the court for purposes of the record.
Go ahead.
I represent non-party Candy Moore, who, as I noted in my papers, is a professional clinical counselor. She sees many of her minor clients through their schools. There were 2 different subpoenas issued by the state, dropped off with the administrator of one of the schools where Ms. Moore sees clients. Both of those subpoenas were identical except for the dates on which Ms. Moore was commanded to appear and testify. For purposes of the record this morning, I'll clarify that 2 separate motions to quash or to modify those subpoenas were filed due to the gap in timing between them. So as a starting point, with respect to the subpoenas, neither was served properly, and that alone is grounds to just quash both of them outright. Still, looking past that procedural. Oh, I'm sorry, Judge, were you trying to interject? I thought I heard something.
No, go ahead. No one's interjecting that I'm aware of.
Looking past that procedural defect, which certainly can be cured by the state, I'd like to address the privilege principles that would be implicated by Ms. Moore's testimony. So fundamentally, Ms. Moore does not dispute that one of the statutory exceptions to the counselor-client privilege, which is referred to as the clear and present danger exception, does have relevance in this case. But Ms. Moore wants to make sure the right procedure is followed here. It's axiomatic that, once privileged information has been disclosed, there's no way for it to be made private again. And Ms. Moore has a legal duty to preserve her client's privilege and wants to make sure that they're not further traumatized by unnecessary disclosures of personal matters, especially given the family circumstances at issue in this case. So as far as that proper procedure, the court should make a finding that the clear and present danger exception applies and order an in-camera review of Ms. Moore's testimony to iron out boundaries of the privilege in advance of trial. The state may assert that it's possible to just object on the fly and try to contain it in real time, but I think it would be prudent for the victims and Ms. Moore's clients to sort this out in advance as part of the resolution of the motions to quash. And so we are asking for an in-camera review of Ms. Moore's testimony before she be compelled
to appear in open court. And the last kind of somewhat collateral point, because it came in, it's not really within the four corners of the motions that were filed, but the state did obtain broad-based consents from both of the victims. And it's our position that those consents are not valid under the law. The legislature, has neither delegated the power of express consent to parents or guardians of a client for purposes of the statute that we're dealing with, which is Revised Code 2317.02 G1B. That's the express consent exception. Yes, it is accurate that a client has to be the consenting party for purposes of that exception. However, the legislature has not granted the power of consent to minors for purposes of this statute. So therefore, we submit that the general rule that minors do not have legal capacity to consent would apply. And that's all, Your Honor.
All right, thank you. Ms. Collins, on behalf of the state.
I'll start with the consents. We'll start backwards. Actually, the consents that the state has forwarded to Ms. Flayhive or her office are from Candy Moore's webpage. So I would assume that as they are the consents that she asked people, the waivers that she asked people to sign, that they would apply in this case, we printed them directly from her webpage. The second thing is I've actually forwarded to Ms. Flayhive's office. I wasn't sure who was still representing her on this case, because Ms. Moore on this case, because I just got another notice of appearance in this case. I forwarded consents not signed not only by the parent or guardian, but also by the juvenile victims. So maybe check with whomever else in your office has entered a notice of appearance here. Those have been forwarded. And the third and most importantly, and I've tried to explain this to Ms. Flayhive a number of times, I'm not sure that I'm going to call this person. I want to speak with her, and I have not been allowed to do that. For trial extensively prior to a trial, I can't do that unless she allows me to speak with her. She had this counselor has filled out a statement. It's in discovery. It's been disclosed. She is a mandatory reporter. I just need to speak with her.
All right.
I feel the motion to quash the subpoena is premature until I'm given an opportunity to even see if I'm going to call her.
All right. Ms. Hamner, do you wish to weigh in? I mean, at this point, the only question is whether or not the subpoena is going to stand and whether there's a release of privilege or not. And it doesn't mean it's admissible at trial, because I have no clue what it is. But
right. For the purposes of this hearing, we're sort of bystanders.
Okay, I understood that, but I want to give you the chance to weigh in if you had any comments you would like to make.
Sure.
All right, thank you. All right, Ms. Flayhive, you have anything else you'd like to respond to?
Yes, Your Honor. I guess I'll also address Prosecutor Collins' points in reverse. So with respect to the reference on these consents to include trial prep and testimony, again, this issue is ancillary to the motions to quash, but we're not aware of any exception to the rules of the professional conduct that would authorize a represented person to be contacted by the prosecutor's office without the prosecutor going through that person's counsel. And we have not objected to having a conversation with Prosecutor Collins. I had reached out to her to try to actually do that, and we have not declined that invitation. So just to respond to that point, I would note that the authorizations that purport to waive Ms. Moore's right to counsel to some extent are not proper for purposes of a consent issue for the victims. And the forms, of course, the court can appreciate a release of information related to medical records can occur in many different circumstances, and these are not the forms that we have proffered as appropriate for a situation such as this case.
Well, let me ask you this, Ms. Collins, you said there's a statement that's in the discovery from this Ms. Moore. Was that a mandated report?
Yes.
All right. Okay. Well, first of all, while the law doesn't specifically grant authority to parents to, at least I'm going to assume that that's correct because I haven't had time to research this. But nonetheless, it doesn't require that. They're the parents. The parents have the right to make decisions for their children. And the legislature doesn't have to come in and specifically say, for purposes of everything under the law, a parent has the right to make that decision for their child. The children are minors, and so they have that right. And so if there's been a signed release from the mother, whether it's on Ms. Moore's form or another form, that's sufficient there to allow the release of information. And secondly, the alleged victims themselves now, as I understand it, have signed releases. So, clearly the motion is not well taken. And now in terms of contact with the witness, the state has the right to talk to the witness. This isn't a situation in which a witness is a party, or I mean, she's not a party to this action. And so, the state has the right to talk to the witness. If you want to be present for that, or another member of your firm, Ms. Flayhive, I mean, I don't know what that would be for, because I think this is a total general consent and total waiver. And so, you'll need to make yourself available if you wish to do that at the times that are convenient to the state and the witness. So the motion to quash is denied. And the witness will be expected to cooperate and to make herself available at a reasonable time to the state to be interviewed to determine whether or not her testimony might be offered at trial. We don't know if it's going to be admissible or not, but that will be the order of the court. Now, is there anything further from counsel?
No, Your Honor. Thank you, Your Honor. Just a point of clarity. Will you issue a written order to this effect?
I'm telling you now, I will if I can, but I've got a really busy schedule right now, and I've got a 4-day trial next week, and I have commitments tomorrow and Friday, so I will try, and today is really bad. That's why I tried to get this in because of schedule next week. I'm telling you to do it, and if I don't have the order to you before the appointment, that's not an excuse.
And is part of your ruling then this morning that the state has to work through Ms. Moore's counsel as a represented person?
No, she's not. She's not she's a witness. Now, well, let me back up. You're saying you want to sit in on these conversations?
Correct.
And why would you want to do that? I've ruled that it's a complete waiver. So why do you need to sit in on it?
So Ms. Moore has a legal duty to ensure that the privilege is being protected.
And I just ordered that it's been waived, and I don't know how I can make that any more clear. It's already waived. So as far as I see it, I think your job is done. Now, you don't have a right to participate in the trial on behalf of the witness. You may sit in on the testimony if you want to, but if I've ruled that it's waived, and I have now, and I'm not going to likely change that ruling. If her testimony is necessary, then she'll be testifying. So I'm not sure what purpose your being in on these conversations would serve. But since you are representing her, I don't see why. It seems to me to be a needless expenditure of the school's funds or her funds to continue to be represented. But I've already made a ruling. It's not going to change. But if that's what you want, all I'm going to say is the state can take the time. You need to make yourself available. If you want to take that responsibility on to communicate with her, you may. You're not to participate in those conversations. You're only to listen. She is to answer questions. If she doesn't cooperate, then that'll be something else that will come before the court. So, don't turn this into something this isn't. Quite honestly, I think this is a tempest in a teapot in the first place. As a mandated reporter, I find it ludicrous that a person would think that they're required to follow the law and report misconduct or alleged misconduct, but yet they're not allowed to testify about it, number one. I think that's an exception. And number two, we have the waivers. I don't know why we are here, because I've not seen this happen in the past on any mandated reporter. So again, if you want to be involved and you're going to want to charge fees and all of this to handle that, that's fine, but you better make yourself available on a wide scale. You're not going to tell the prosecutor, I don't have any time until August the 15th at 5 o'clock in the evening. That's not going to happen. And so you will set up the time, place. It'll be at the prosecutor's office, or however they want to handle it. If they want to do it by phone or Zoom or whatever, that'll be up to them. They're going to call the shots. You understand?
Understood, Your Honor.
All right. Is there any other clarity you need?
So is the court's decision that their counsel's obligation to communicate with counsel of a represented person, not a party, the rule is broader than party, does not apply in this case, or just that I need to make myself available and Prosecutor Collins will work through me to set up a meeting, and in the event that she decides to proceed with that strategy?
I'm not sure I understand your question.
Judge, may I?
Go ahead.
Oh, so in email exchange with Ms. Flayhive, for example, we called and left a message for Candy Moore that we didn't have a trial, and she said that was communication with a represented person that is a violation of the rules. And I said the subject of the communication would be the testimony, not the fact that the trial has been continued. She's wanting me to call her office to schedule the appointment, and then she would contact Candy Moore, and then Candy Moore would contact her, and then she would call me back, when honestly I just am probably going to call Candy on the phone and talk to her over the phone.
Again, I don't think that the communication in a criminal trial by the prosecutor's office with a witness who was a mandated reporter, where privilege has been totally waived, has to be through the attorney. And I don't think it's a violation of the rules of professional conduct, because it's not about a matter affecting her rights. It's about her protecting someone else's rights, which I've already ruled upon are totally, completely waived. Now, however, if you insist on continuing to be involved in this case, which again, I don't see any reason for, because there's not going to be any change in the ruling of the court, so I don't really see what the purpose is, because you're not going to be able to tell her whether she answers a question or not. She's going to cooperate with them just like any other witness, any other fact witness, and if she doesn't, then she's exposing herself. And I'm not going to put up with interference. I've never seen this. I've been doing this for 47 years. I've had motions filed to quash sometimes, and once the waiver was on, there was no problem. And so, or if the ruling of the court was that the privilege was waived, there was no problem. That was it. The attorneys were out of it. Now, I don't understand why you want to continue in this. Just because she's a represented person doesn't mean that you'd have to continue to represent her, because the purpose for which this hearing was held has been ruled upon and adjudicated. So that completes the matter. So, she's not a party to this action. There's not a case pending against her. She's a witness. Now, however, as I said, if you want to insist to continue to be in this case for whatever reason you think is necessary, that's up to you. And I'm going to have the prosecutor, as far as is reasonable, we can facilitate that through you. But you better be available. And I don't mean, like get a call today and then call back next Monday. I mean, you need to be available. Because if you're not going to be reasonably available to facilitate this, then I think it's appropriate for her to make the appointment directly with Ms. Moore.
So, Your Honor, are you ordering the witness to...
How much more clear can I make this, Ms. Flayhive? You are making this way more complicated than it is. The witness will testify. The witness will be subject to an interview. Now, that's to be done. When do you want to do that, Ms. Collins? I'll just go ahead and make it real clear. We'll set a date right now.
I actually am available tomorrow morning, 9 o'clock.
All right. Ms. Flayhive?
I can be available, but...
9 a.m. tomorrow morning. You want to do that by phone or Zoom, Ms. Collins?
Phone.
All right. So you'll need to set up a three-way conference call then. So Ms. Flahive, you can take care of that by contacting your client. If that's what you want to do, then you can make her available and make arrangements for the conference call. Now, is that it?
It is from the state.
Your Honor, I would request a written opinion.
Ms. Flahive, you're really testing my patience here. I will put on a written order. I will put that order on. You know, I have a lot of things going on my plate. And again, this is a tempest in a teapot. You know, I don't understand. And this is you, not your client, that's being difficult. I'll make that clear for the record. You know, because, you know, I understand her, you know, and this happens all the time where people come into court and say, well, I have to have an order to show that the privilege has been waived or that it doesn't apply. And I've given you that, and I'll put that on. You know, I'll put that on. You know, even though it's going to be a real problem for me, you know, in my time and schedule, because I got a lot of stuff on my plate today, you know, I'll get it done. Now, anything else?
No, Your Honor.
All right. I'm ordering the movement to pay the court costs of this proceeding. All right. Anything, Ms. Collins?
No, Your Honor.
Ms. Habner?
No, Your Honor.
All right, thank you. That is a case of just, I better not say it.
Seth Beatty.
What's that case number?
Case number 23 of 90.
090? All right, this is case number 23 CR 90, State of Ohio versus Seth Beatty. Appearing on behalf of the state, Assistant Prosecutor King, on behalf of the defendant is Attorney William Armentrout. You are Seth Ryan Beatty.
Yes, Your Honor.
All right, this is a final pretrial, and appears that there's been a plea agreement reached. The defendant is charged in a 2-count indictment with pandering obscenity involving a minor. Mr. King, has the alleged victim of the charges been notified of the time, purpose, and place of this hearing, the right to be heard?
Yes, Your Honor. It's my understanding the alleged victim and her custodian intended to be present here today. I just received word as I was walking over here that they were caught in a traffic or a crash somewhere and they were rerouted. They were trying to make it here. They've not yet arrived.
Okay. All right. All right, so the defendant is charged with 2 counts of pandering obscenity involving a minor, second-degree felonies. It appears that there's a plea agreement form here, which indicates the defendant is going to plead guilty to 3 fifth-degree felonies through a bill of information. And on page 3 of this, well, let me go back a little bit. It says it's going to be 3 counts of illegal use of a minor or impaired person in a nudity-oriented material performance, violation of 2907.323A3, fifth-degree felonies. All right, and on page 3, there is a sentence about halfway down the page. It says, "I enter this plea voluntarily," and there's a signature line for signature defendant. It looks like Seth Beatty's signature. Did you sign this agreement, Mr. Beatty?
Yes, sir, Your Honor.
When did you sign it?
That'll be yesterday.
All right. Now, when you signed this agreement, did you understand it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir, Your Honor.
Okay. All right. Did you have enough time to fully consider this matter before you made this decision?
Yes, sir.
And do you feel that you were rushed or pressured in any way into doing this?
No, sir.
And you've had enough time to fully consider this matter before making this decision?
Yes, sir.
All right. Excuse me. All right. Hold on here a minute. I've got a Zoom called up here, and I think I might have clicked on the wrong one. Yeah, I did. That's why there was no one on there. Okay.
Recording in progress. Recording stopped.
All right, for those of you who are on the Zoom call, I'm handling a plea here in the courtroom, so it'll be about 15 minutes or so, or maybe a little bit longer before we get to you. So if you want to just mute and wait for me to come back on, right now I'd say it'd be about 1:30. All right. So, Mr. Beatty, you were indicted by the grand jury, as I've indicated, on 2 counts. The grand jury is a group of citizens that live in this county that meet about once per month on the average to consider evidence of alleged crimes. They do not decide whether somebody's guilty or not guilty, but they simply decide whether there's enough evidence to warrant the case going forward. This is your victim and mother?
Yes, sir, Your Honor.
All right, so the record will reflect that they are present now. It's because they don't make the final decision, it requires a vote of only 7 of the 9 people that are on that jury to return an indictment. And then once that indictment is returned, then it's served on the person that's named, and they come before the court like you did originally. And so that happened on the other, is that the indictment is going to be dismissed, and in lieu of those charges, you're going to plead guilty to 3 charges through what's called a bill of information. And I have that bill of information here. And I'll read it here in a moment, but what a bill of information is a charging document that's basically the same as an indictment, except that it only requires the prosecutor to sign it, or an assistant prosecutor to bring it before the court. Because in order to do that, the person has to waive the right to have that case submitted to the grand jury. And so if it were going to the grand jury, it would require them to hear evidence, and at least 7 of those people vote to return an indictment, and then it would be signed by the prosecutor and the foreperson. And a bill of information, instead of going to the grand jury, the person just agrees that this is going to be the charge that's going to be submitted to the court for consideration without the action of the grand jury. And so the charge in count 1 is that on or about April 25, 2023 in Highland County, Ohio, you did possess or view any material or performance that shows a minor or impaired person who is not the said Seth Ryan Beatty's child in a state of nudity in violation of section 2907.323A3 ORC. And then count 2 alleges the same charge, the same language. And then count 3.
We'll fucking do that.
All right. Mr. Nicholson, would you mute yourself there?
18 months.
Mr. Nicholson, would you mute yourself there, because I'm having another hearing here in the courtroom. So I'll start the Zoom hearing at about 1:30.
Is her name? Yes. I said David Nicholson.
All right. I muted him. All right. Yeah, okay. All right. Thank you. And so, and these are relating to 3 separate images?
Correct, Your Honor.
All right. So those are the charges. That's what's in the bill of information. Now, the difference between these charges and the indictment are second-degree felonies, which carry a possible prison term of between 2 and 8 years and a fine of $15,000, and designation as, I believe, a Tier 1 sex offender. Now, the 5th-degree felonies, so these charges are 5th-degree felonies under 2907.323A3, all 3 of them. And they carry a possible prison term if convicted of between 6 and 12 months each, and a fine of up to $2,500. And so instead of...
Can they hear me?
Mr. Nichols, just mute yourself. I'll call your case when I'm ready. Until then, just mute yourself. I muted you a minute ago, and you unmuted.
Just 10 minutes. My name's Dwayne Devine, sir.
Okay, well, mute yourself too, Mr. Devine. Okay?
Okay, sorry.
Whatever, okay. All right. Now, and that still requires a Tier 1 designation as a registered sex offender. But the maximum penalty then for those offenses could be 36 months total, since 12 is the maximum on each count, and a maximum fine of $7,500 versus potential of 16 years and $20,000 fines on the indictment counts. You understand that?
Yes, sir, Your Honor.
All right. Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you serve a prison term in this case, once you complete that prison term, it is mandatory that you be put under post-release control supervision for 5 years. And what that means is that you'll be supervised under the term set by the Adult Parole Authority by a parole officer. And if they determine during that period of time that you are not in compliance or fail to comply with those rules, they can return you to prison, even though you serve the entire term that the court ordered, for an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence could be imposed for that offense by that court could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurred, that has to be served consecutively to the sentence in that new case. Do you understand that?
Yes, sir.
Now, under the law, the offenses for which is proposed that you plead guilty are not mandatory prison terms, and so it's not required by law to sentence you to prison. The court does have the right, instead of prison, to impose community control or probation, which means you would be subject to being supervised by a probation officer on a term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were not compliant, they would file a written notice of that with the court. There would be a hearing. And if the outcome of the hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for the 36 months and fine you $7,500. Do you understand that?
Yes, sir.
All right. Now, I have before me then a waiver of prosecution by indictment, because as I said to you, the only way we can do this is if you agree to waive that right. And so this says that you've been informed by the court of your constitutional right to have the matter submitted to the grand jury and your right to be prosecuted by indictment, and that being represented by William Armentrout, attorney at law, Hillsborough, Ohio, you do hereby freely and voluntarily waive prosecution by indictment, agree to proceed in this matter by bill of information, and it's signed 8/1/23, and I see signature Seth Beatty and Mr. Armentrout's signature below. You signed this document that I just read?
Yes, sir, Your Honor.
Okay. And I assume that means you had a copy of the bill of information yesterday, Mr. Armentrout, more than 24 hours prior to this hearing?
Yes.
All right. Okay, now, I read the 3 charges to you a moment ago. You recall that?
Yes, sir.
And you understand what it is you've been accused of having done
sir.
in each of those 3 counts, what they said you did, when, where, and how they led you did it?
Yes, sir, Your Honor.
And you understand the possible penalties for that offense?
Yes, sir, Your Honor.
Now, have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, the possible outcomes of a trial with your attorney?
I have not.
No, we discussed everything.
Oh, yes. Yeah, we have. My bad.
Are you satisfied with his advice and competence in this matter?
Yes, sir, Your Honor.
Are you under the influence of any types of drugs or alcohol?
No, sir.
Have any threats been made against you to make you plead guilty here today?
No, sir.
Now, on page 2 at the bottom, and I think going over onto page 3, there are some sentences that are printed in bold in this agreement and underlined, and I'll read those at this time. Defendant shall enter a plea of guilty to the bill of information. The state will dismiss count 1 and count 2 of the indictment. State and defense jointly recommend 8 months incarceration on each count of the bill of information to be served consecutively for a total term of incarceration of 24 months. Defendant shall be a Tier 1 registered sex offender. The state agrees to take no position as to judicial release. Now, is that your understanding of the agreement?
Yes, sir, Your Honor.
And has anyone promised you anything other than that to get you to plead guilty here today?
No, sir, Your Honor.
Now, under the law, Mr. Beatty, the matter of sentencing is up to the court, not the parties. And so even though there's an agreement that sentence ought to be 8 years on each consecutive, if you plead guilty, I'm not bound by that recommendation. I can impose any sentence that I think is appropriate under the law. You understand that?
Yes, sir, Your Honor.
Same thing with judicial release. The state says it's taking no position. It doesn't mean it'll be granted. The court is one to make that decision based upon the information at the time that's submitted. Do you understand that?
Yes, sir.
All right. Now, do you hold any license or certification from the state of Ohio, any governmental agency of the state of Ohio that regulates any profession or occupation?
No, sir, Your Honor.
All right, now you have certain constitutional rights, you must understand, before I can accept a plea from you on this case. First of all, you do have a right to have counsel. And were you appointed or retained?
Appointed.
Appointed, all right. to have counsel represent you. And since you did not have the funds to hire one, I appointed Mr. Armitrout. Now, the appointment wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you would like him to provide. So if you decide you don't want to do this, he will still represent you and defend you, including trial, if that's what you want. You understand that?
Yes, sir, Your Honor.
Right, now under the Constitution, Mr. Beatty, you have the right to have a jury trial on each of these counts, which means that a jury of 12 people would be selected from a group of citizens that live in Highland County that would be summoned for jury duty on your trial date. After they are selected, the evidence would be presented, the court would then instruct them on the law, and then that jury would then decide by unanimous verdict, meaning all 12 of them would have to agree, as to whether the state proved your guilt on each of the 3 counts. So the verdict would be unanimous on each count. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up, your right to have an attorney. In that case, you have what's called a court or bench trial, meaning the judge is the one who hears the evidence, applies the law, and decides whether or not the state proved your guilt. Do you understand that?
Yes, sir, Your Honor.
Now, under the law and the Constitution, Mr. Beatty, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir, Your Honor.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena. That forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir, Your Honor.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you're being accused. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each of the offenses by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally, Mr. Blosser, in the original indictment, you entered a plea of not guilty. Not guilty plea denies allegations in the charge, denies you've committed any crime, and it exercises or invokes all the rights I've just described. Now, in this situation, in this plea agreement, it's proposed that you plead guilty to the 3 charges in the bill of information. Plea of guilty would be the opposite of a not guilty plea in that it would admit the allegations that are in the bill of information in each of those counts, admit that they're a crime, and that you committed the crimes in each of those 3 counts. The plea of guilty to the bill of information then would waive or give up all the rights I have described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives, it gives up your privilege against self-incrimination because you're the one saying you're guilty, that's what she finds you guilty. And waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, which I think is what's proposed here. And finally, it waives, gives up any right to file an appeal you may have had or feel you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir, Your Honor.
And are you a U.S. citizen?
Yes, sir.
Now, did you sign this plea agreement voluntarily?
Yes, sir.
And is this what you still want to do?
Yes, sir, Your Honor.
You're going forward today voluntarily?
Yes, sir.
You have any questions about the charges or the possible penalties?
No, sir, Your Honor.
You understand them?
Yes, sir.
Do you have any questions about the plea agreement? You understand?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the court, and there's no guarantee you'll get judicial release just because the state's not opposing it.
Yes, sir, Your Honor.
Okay. Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand that?
Yes, sir.
Do you have any questions about the waiver of a grand jury and the bill of information as to these new charges?
No, sir.
You understand that?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that here today?
No, sir.
You understand that?
Yes, sir.
Is there anything you need to speak to Mr. Armentrout about before we go any further?
No,
You
sir.
have any questions at all about anything I've explained to you this afternoon?
No, sir, Your Honor.
All right? Before I accept the plea, is my I didn't ask this, Mr. King, but it's my assumption that the victim and or the representative of the victim is in agreement with this settlement and plea agreement.
That's correct, Your Honor. The state has consulted with the legal custodian of the victim who's present here today, and she has approved of this agreement.
Okay. All right. Then, is it your intention, Mr. Beatty, to go forward and plead guilty to each of these 3 counts pursuant to the plea agreement?
Yes, sir.
Then as to count 1, which alleges on or about April 25, 2023 in Highland County, Ohio, you did possess or view any material or performance that shows a minor or impaired person who is not the said Seth Ryan Beatty's child in a state of nudity in violation of section 2907.323A3 of the Ohio Revised Code, illegal use of a minor or impaired person in a nudity-oriented material performance, a felony in the 5th degree, the charge of illegal, let me get that, because it's a long one, illegal use of a minor or impaired person in a nudity-oriented material performance, a 5th degree felony, carrying a possible penalty between 6 and 12 months imprisonment, a fine of $2,500, and a Tier 1 sex offender registration. How do you plead?
Guilty.
And then as to count 2, which alleges is the same language but refers to a different image, otherwise it's the same offense and the same penalty. How do you plead?
Guilty.
And as to count 3, which again is the same language, simply refers to a separate image, how do you plead?
Guilty.
All right, thank you. Be seated. All right, the court finds that on this day in open court, the defendant was advised of all of his constitutional rights and made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. The plea is accepted and ordered filed. The defendant is found guilty of each of the 3 counts in the bill of information, and the indictment is dismissed. Now, based upon the language in the plea agreement and the nature of the offenses that this court's almost 99.9% of the time orders a term of imprisonment for sex offenses, and so the court is not going to order a pre-sentence report, and I'll proceed with sentencing forthwith. Now, before I go to the sentencing, however, I do have to inform you of the sex offender registration requirements under the law. And it looks like I have before me a paper here that's signed Seth Beatty, 8/1/23. It's titled the Explanation of Duties to Register as a Sex Offender or Child Victim Offender under the law. And you did sign this yesterday?
Yes, sir, Your Honor.
All right. Well, I'll still have to go over it in the record, so I'll try to make it as brief as possible. Because of these 3 offenses, you're hereby designated as a Tier 1 sex offender child victim register. That means that you'll be required to register for a period of 15 years in person and verify your information annually, once a year. Now, that means that you're required to register in person with the sheriff of any county in which you establish residency within 3 days of going into that county. Or if you're staying in that county temporarily for more than 3 days. You must register in person with the sheriff's office. Now, you must also register in any county in which you establish a place of education immediately upon going into that county. So if you're going to a trade school, college, job training, something of that nature, vocational training, you have to register in that county as well. If you become employed in a county other than your county of residence for more than 3 days in a row or a total of 14 days in any one calendar year, then you're required to register with the sheriff of that county as well. And so it's possible you could be required to register in up to 3 counties: where you live, where you're going to a place of education, and where you're working, if you're working there more than 3 days in a row or 14 days in a year. Now, if you go into another state to live or to work or to go to a place of education, then you must register in that county of that state with the officer that's charged under that state's law with maintaining the registry of sex offenders. If you are going to be gone from your place of residency for 7 days or more, say you're going to go on a vacation, or you're going to be hospitalized, or you're going to go stay and take care of a relative or something, then you have to notify the sheriff of your residency, county of residence, of that, where you will be, how long you expect to be there, and then notify him on your return. Now, if you change your residence or place of employment or place of education, then you have to provide written notice of that change to those sheriffs of those counties in which you register. And again, if you're going to change residency, you have to do that 20 days prior to changing. Except for employment, you have up to 3 days after you're in that county to change, because you can be in a county 3 days before you have to register, but after 3 days you have to register and report that change. If you should ever have a situation where you do not have a fixed address, then you'll be required to provide a detailed description of the place or places you'll be staying, and then no later than the first business day immediately following the day you do obtain a fixed address, you must register with the sheriff that fixed address. Now, under federal law, it's also required that if you should have a passport and intend to do any international travel, that you must notify the registering sheriffs where you're registered at least 21 days before you travel. If you do not do that, you could be subject to a criminal prosecution. You're also required to provide a notice within 3 days anytime you change your vehicle, an email address, an internet identifier, a telephone number that you use or is registered to you in each of the counties in which you've been required to register. You must verify your changes at least.
Fix this leaky dam.
You must register. You must register or provide your verification in person. You can't do it over the phone or by email or anything of that nature. It has to be in person. It cannot be any earlier than 10 days prior to your verification. So yours is annually, so you can't do it any earlier than 10 days before that anniversary date. Now, in the event that you fail to register or provide the verifications that are required under the law, or notices of changes in any of the things that are required to be notified, that could result in a prosecution for violation of provisions of Chapter 2950 of the Revised Code, which would be felonies. And I've already indicated that you have signed this. And so your expected residence would be Frankfort, Ohio, which would be Ross County. And so that would be the county, and that's in Chillicothe, Ohio. I don't remember the zip there. And I believe that is North Paint Street is where the jail is located. But is that where it still is, Lieutenant Brown, the jail in Ross County, North Paint?
Yes.
Okay, thank you. All right. Now, the court will now proceed with sentencing. Anything from the state?
Only was contained in the plea agreement, Your Honor.
And does the victim or victim's representative wish to be heard on a matter of sentencing?
No, sir.
Mr. Armentrout?
I would ask the court to follow the recommended sentence of 8 months on each count for a total of 2 years. Seth has always cooperated with me and I think with authorities. Never wanted this matter to go to trial, completely admitted what he had done here. I know that the victim herself is I think she's still a minor, probably 18 this year, with the idea of putting some photos out there. Seth obviously regrets what has got him to this position, made some bad choices and mistake. We'd ask the court to follow the agreement, and at some point we may ask the court to consider another release.
All right, Mr. Beatty, anything you would like to say?
Yeah, I'd just like to apologize to Max and Kim.
Dan, any of the jail time credit? None? All right. Were you arrested on the 26th of April?
Yes, sir.
Well, Mr. Beatty, you know, this is one of those situations where the existence of this technology that we have now, cell phones, while it can be a great thing, is also, unfortunately, an instrument that can be misused, just like a lot of other things, like guns and cars and things of that nature. And, you know, being involved with a person who's under age and then taking photographs of them, obviously, you know, that's something that the law frowns on. And even though, you know, there's not a great difference apparently in your ages, nonetheless, a minor is a minor. You know, I see cases all the time where pictures of minors have been taken and they go out on the internet and they get downloaded and copied. And once they're out there, it's virtually impossible to ever remove them. You can delete them from your devices, other people can delete them, but you know, there are people out there on the internet that do this for a living, where they do nothing but troll the internet and download pictures like this and then put them into files and then sell them to people, and people that take for some reason, perverse interest in that type of thing. Now that's not you. But you know, what you did could have resulted in something like that, and that's why this law is there, is to protect children. And it is a sex offense under the law, and so unfortunately that means that for you, that you'll be required to register for 15 years. The good part is that you know, you're a young person, and hopefully you're going to use this experience to the best extent possible, and that is an understanding of personal responsibility and the need to think about your actions before you do them. So based upon that, the court will follow the plea agreement, and it's ordered that you be sentenced on each count of the bill of information to a term of 8 months. Each of those sentences run consecutively to each other for a total of 24 months. And according to my calculations, you have 98 days of jail time credit, which will be applied to that sentence. Now, the court finds that consecutive sentences are appropriate in as much as that is part of the negotiated plea stipulated by the parties. They're committed a series of misconduct, a series of one course of conduct, but 3 separate offenses, and that the harm is such that one single sentence would not adequately reflect the seriousness of the offenses, and the sentence that's being imposed is not disproportionate to the harm caused, being a middle of the road sentence, actually toward the lower end of the possible sentence of maximum of 12 months. Now, upon completion of this sentence, Mr. Beatty, if you do serve the entire sentence, because the matter of judicial releases won't be known until it comes up, I would suggest you not file that immediately, given the nature of this offense. These offenses at court's view, that probably would be at least 9 to 10 months before I would consider it. Now, and you only get one shot. If you file too early and I deny it, you don't get another shot. Unless I decide on my own to do that, reopen it. Now, upon completion of this sentence, if you serve the entire sentence, it will be mandatory that you be supervised by a parole officer in the term set by the adult parole authority. And that'll be for a period of 5 years. And If you commit any violations of those conditions, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term for all violations. However, if your violation is a new felony, then in addition, whatever sentence a judge in a new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, the court can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you complete your prison term, not while you're in prison, but once you complete it, you could do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor. No, Your Honor.
All right, you're remanded to custody, Mr. Beatty. Right. Case number 23 CR 67. Is that the only charge we have here? Yeah. Okay. State versus Stephen R. Gibson. Mr. Gibson is appearing by video or Zoom from the jail. His attorney is Captain Hapner, appearing from her office, appearing on behalf of the state's prosecuting attorney Collins. The defendant is charged with one count of failure to appear, a fourth-degree felony. And I see that the state has provided discovery and a bill of particulars. And Ms. Hapner, did you provide your discovery?
I don't believe I've done so yet. I'll get that this week.
All right. Well, final pre-trial is the 23rd, and the trial set for the 12th, so you have until the 23rd of August to do that. Do you anticipate any pre-trial motions?
I do not.
All right. And has there been a written plea offer provided?
There has been.
Okay. Is your client aware of it?
No, not yet.
Okay. All right. Are there any other matters we need to discuss on this case at this time?
No, Your Honor.
All right. Thank you. All right. Gary. All right, case number 23 CR 125, State of Ohio versus Gary Lee Pettiford. And are you Gary Lee Pettiford appearing there from the jail?
Yes, Your Honor.
All right, Mr. Pettiford's attorney is Jeffrey Blosser. This matter is being conducted by Zoom. Mr. Blosser is appearing from his office. Representing the state is prosecuting attorney Collins. The defendant is charged with 2 counts of rape, both first-degree felonies. This is a first pretrial, final pretrial set for August 2, and trial is set for August 21. See, the state did provide the discovery, and I don't know, was there a bill of particulars as well?
Yes, there was. We filed a notice of that on
Okay.
July 17th, Your Honor.
All right. And you received both of those, Mr. Blosser?
I did, Your Honor. Thank you.
All right, and your discovery will be due then by the final pretrial. Are you anticipating any pretrial motions?
No pretrial motions, Your Honor. Filed my responses to discovery yesterday, I believe.
Oh, okay, all right. And has there been a written plea offer provided yet?
There has been. I believe is this not the final pretrial?
I don't think so.
It is.
Yes, it is.
It is.
Oh, it is. Okay, it is actually the final pretrial. The trial's set for August 21. Yeah, it is August the 2nd already, isn't it? Yeah. Okay. In the event that there is not going to be an acceptance of a plea offer, we'll need a written rejection signed for that, Mr. Blosser.
I've done so, Your Honor. Provided a copy via scan and email to Ms. Collins just a short time ago, actually.
Okay. All right. So I think I've said this to you before in the past. I'm not positive, Mr. Blosser, but I'll also say it for the benefit of your client, is that if there's going to be any resolution of the case short of trial, it would have to be 2 weeks prior. And so that would be August the 7th, which is next Monday, which is going to be problematic because we have a jury trial going on. But if that does happen, we'll figure out something to make it work. But if it's not done by Monday, if we're at least scheduled by Monday, then jury notices will go out and there won't be any plea bargaining after that.
Yes, sir.
All right. Anything further from counsel?
No, Your Honor.
All right.
No, Your Honor. Thank you.
Mr. Baker next, please. Errol Baker. Errol Tyrone Ty Baker appearing from the jail.
Yes, sir.
All right, this is case number 23 CR 130, State of Ohio versus Errol Tyrone Ty Baker. This is a pre-trial being held by Zoom. The first pre-trial, final pre-trial set for the 16th of August and trial set for September 11. The defendant is charged with aggravated trafficking and aggravated possession of meth, having a weapon under disability, and a forfeiture. Let's see here. Looks like the state did provide discovery. And let's see, was there a bill of information of particulars as well? I don't see it.
I don't believe that was requested.
Okay. All right. Your discovery will be due by final pretrial, Mr. Subpoena. Do you anticipate any pretrial motions, Mr. Subpoena?
Your Honor, I'm still going through the discovery. I just dropped off thumb drive today to Ms. Collins. So we're still going through the discovery with my clients. Whether I have motions or not is unknown at this time.
All right. Well, those will be due by the final pretrial then. And has there been a written plea offer provided yet?
Yes, Your Honor, on July the 18th.
Okay. Is your client aware of that, Mr. Subpoena?
He is, Your Honor.
Okay. All right. Are there any other matters that we need to address at this time?
No, Your Honor.
All right. Thank you.
Thank you.
Let's see. Is Mr. Eisen appearing from the jail?
Yes, sir.
All right, this is case number 23 CR 102, State of Ohio versus Joey Allen. Eisen appearing on behalf of the state is Prosecuting Attorney Collins. Appearing on behalf of the defendant is Attorney Dennis Kirk. This is a Zoom pre-trial. Mr. Eisen is appearing from the jail. He is charged with 1 count of aggravated possession of methamphetamine, a third-degree felony. This is a final pre-trial, and I'm trying to look here. Yeah, trial set for the 31st of August. All right. Okay, I see that state did provide discovery. Have you provided discovery, Mr.?
Your Honor, I have not. We just found out 2 weeks ago at the last pretrial, the day of the pretrial, that he was in the Adams County Jail. And then I was on vacation after that. I did not realize they brought him back this morning until bailiff called me. So I've not been able to speak to him yet to see if he has any discovery or witnesses. Was hoping the court could have him held up here and I could meet with him tomorrow morning.
All right. Deputy, if you would, hold Mr. Eisen until noon tomorrow so that Mr. Kirk can talk with him.
Yes, sir.
Okay. All right. And if you have any pretrial motions, I'll give you until next Wednesday to file those. That would be the 9th.
Thank you, Your Honor.
And do you have a written plea offer?
Yes, Your Honor.
Mr. Kirk, you have it?
Yeah, I do. And I did have a very brief phone call with Mr. Eisen before the first pretrial and told him about the offer.
Okay.
And I'm hopeful we can resolve the case.
All right. All right. Is there anything else to be discussed then?
No, Your Honor.
All right.
No, Your
Thank
Honor.
you. All right. If we can get. All right, are you Donald Hill there at the jail?
Yes.
All right, this is case number 23 CR 82, State of Ohio versus Donald Hill. This is a pretrial being conducted by Zoom.
It's Bill.
Let's see, where's Mr. Armentrout? I thought he was on there. Oh, well, we'll have to stop until we get him. I'll have to, he went, supposed to go back to his office and all gone. So we'll skip over then to, all right. Okay, who's the person that's there on the screen marked Sweden Carter? You need to unmute.
Dwayne Devine.
Tell him that we're ready for him. He's supposed to log in on Mr. Hill. All right, what is your name?
Dwayne Devine. Dwayne Devine, sir.
All right. Mr. Devine's attorney is Ms. Hackett. All right. All right. Case number 23 CR 112, State of Ohio versus Dwayne. All right, case number 23 CR 112, State of Ohio versus Dwayne David Devine. This is a hearing being conducted by Zoom, a pretrial hearing. Mr. Devine is appearing on the screen marked Sweden Carter. His attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, prosecuting attorney Collins. The defendant is charged in a 5-count indictment, selling dangerous drugs, possessing dangerous drugs, trafficking marijuana, trafficking drugs, possession of drugs. This is a first pretrial, final pretrial. Trial is set for August the 28th. Now, it looks like discovery has been provided by the state in the bill of particulars. Have you provided your discovery, Ms. Hapner?
I thought that I had, but if I have not, I'll get it over this afternoon.
All right, I don't see it in here. All right.
It's possible that I haven't brought it over.
And there are no pretrial motions?
That's correct.
All right, and has there been a written plea offer provided?
Yeah, I received a new plea offer earlier this week, and so my client's been in contact with me. He is aware of that new offer, and I told him he'll need to let me know by next Friday at the latest.
Okay. All right. Are there any other matters that need to be discussed?
No, Your Honor.
All right, then you can go ahead and sign off, Mr. Devine, and stay in touch with your attorney because your trial date's coming up, and you only have you have to make a decision 2 weeks before your trial date. Okay, thank you.
Yes, sir.
All right. right, State of Ohio versus Jason McCoy, 23 CR 121. This is a Zoom hearing. Pre-trial, Mr. McCoy is appearing on the screen marked Cameron Maddox. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged in a 4 out of 6 counts with a co-defendant. 2 counts of aggravated trafficking of methamphetamine, 2 counts of aggravated possession, all third-degree felonies. This is a final pre-trial. We have a trial date of August 28th. Now, discovery complete from both sides?
It is, Your Honor.
All right.
Yes, we filed today, Your Honor.
And there's no pre-trial motions?
No, sir.
All right. Where do we stand on this case, counsel?
If I may, Your Honor, I have already coordinated with Ms. Oyer and Ms. Collins for, shall I say, status/plea hearing for Monday, the August the 14th at 1:45.
Okay. All right. Then we'll have that hearing then here in the courtroom. So Mr. McCoy, mark that down. Monday, a week from Monday, the 14th at 1:45. All right.
Yes, sir.
Stay in touch with your attorney. Anything else we need to discuss?
I'll call you, Mr. McCoy. No, sir.
All right. Okay, let's do... All right, go ahead and put us on Dixon. Yeah. Case number 23. Oh, he's getting him here to the probation office. There he is. All right, are you Joey R. Dixon Jr. there at the probation department?
Yes, Your Honor.
All right, just case number 23 CR 78, State of Ohio versus Joey Dixon Jr., Joey Ray Dixon Jr. This is a pretrial being conducted by Zoom. Final pretrial. Mr. Dixon's appearing from the probation department. His attorney is Jacob Wagner, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Defendant is charged in a 6-count indictment with endangering children. I believe this trial is set for August 17 and 18. All right. Now, I've been presented with a proposed polygraph stipulation set for August the 9th in Columbus at the Highway Patrol. So is that, counsel, that's what's going to happen here today?
Stipulation, yes, sir, if we may.
All right. All right, Mr. Dixon, I'm going to hold this up to the camera. Do you see that agreement for taking a polygraph?
Yes, Your Honor.
All right. And there's a page 3. There's a place that about halfway down that reads freely and voluntarily agreed, stipulated this due day of August 2023. Right below that defendant, there's an X that says Joey Dixon Jr. Is that your signature there on the?
Yeah. Yes, Your Honor.
Mr. Dixon, normally polygraph results are not admissible in a trial, but there is one exception, which is if the parties both agree in writing as to the test, then the results of that test can be admitted into court at a trial, if there is a trial. Now, it doesn't mean that if you pass the polygraph that the case will be automatically dismissed. It doesn't mean that if you fail or found to be deceptive that you're automatically guilty. There could still be a trial, but the results of the answers to the questions that you were asked at that time could be introduced at the trial. So if they were in your favor that said you were truthful, you can introduce them. If they were unfavorable and the opinion was that you were not being truthful, then the state could introduce that against you. You understand that?
Yes, Your Honor.
All right. Well, then you're to be at Columbus on August the 9th at 8:30 a.m. at 1970 West Broad Street, the Highway Patrol Office, so make sure you're there. All right. Anything further from counsel?
May I, sir?
Yes.
I know we had previously discussed this matter, Your Honor. As far as the 17th jury trial date, I mean, my client's out. I know we've previously waived time. The court indicated they would be fine. I guess I'm just following up that if we could vacate that and set this out in September, Your Honor, we'd be greatly appreciative.
The state has no objection. I believe that the co-defendant would have no objection as well.
That is correct.
Who is the co-defendant?
Reese Fist.
Okay, she's not on the docket today, is she? Oh, yes, she is.
She is.
All right, Ms. Witt's representing her.
Yes, she's at the probation department as well.
All right, then does she have any objection to this?
No, she does not.
Continued, okay. All right, well, the court will grant the continuance since we do have a pretty busy August anyway. And so court will grant the continuance at the request of counsel. I think they're both in out on bond, are they not?
They are.
Wrong. I have that problem all the time. This, there we go. There we go. All right, the court then will grant the continuance. We'll set a final pretrial. For August 23rd at 2:15 p.m. Trial will be set for September 11 at 8 a.m. and time will be charged to the defendant. All right, is there anything further to discuss in this case?
No, sir.
All right, thank you. Then make sure you're at that polygraph, Mr. Dixon. Make sure you stay in touch with your attorney and probation office. Thank you.
Thank you, Your Honor.
Chris Hunter, that needs to go down that way.
Yes.
All right. This is a pre-trial being conducted by Zoom. Mr. Hill's attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Defendant is charged in a 5-count indictment with sexual battery, third-degree felonies. Matter is set for trial on August 21, and this is the final pre-trial. So where do we stand on this case, counsel?
It's prepared for trial.
Mr. Armentrout?
You're muted, Bill.
You're muted, Mr. Armentrout.
We're still within the court's order on resolving the matter, Judge. And negotiations have been ongoing, but we're not there yet. It's scheduled for the 21st of August, and that's fine if we don't get it resolved. We still have 4 or 5 days to be within court rule.
Right. All right. Anything else we need to discuss?
No, sir.
All right. Thank you.
I'll be out, Don.
All right. Let's do Reese Fist. Let's see, what time did I just set Mr. Dixon for pre-trial? What date?
2:15, I think, Judge.
Yep, 2:15.
Yeah. August the 23rd?
Yes.
Yeah, okay. Thank you. All right, this is case number 23 CR 77, State of Ohio versus Reese Tierney Fist. And are you Reese Tierney Fist appearing there from the probation department?
Yes, Your Honor.
All right, this is a final pretrial. Ms. Fist is set for trial on the 17th. However, we just continued that to September the 11th because the co-defendant is taking a polygraph, and this is scheduled to be a joint trial. And as I understand, Ms. Witt, I forgot to say Ms. Witt is appearing from her office on behalf of the defendant, who's appearing from the probation department, and Prosecutor Collins on behalf of the state. Ms. Witt, you're in agreement with the continuance?
Yes, we are, Your Honor.
Okay. All right, so the matter will be continued for final pretrial to August the 23rd at 2:15 p.m. The matter of trial will be set for September the 11th at 8 a.m. All right, any other matters we need to discuss on this case?
No, Your Honor.
No, Your Honor.
All right, stay in touch with your attorney in the probation department then, Ms. Fist. Thank you. All right. Okay. This is case number 23 CR 76, State of Ohio versus Rachel L. Button. And you're Rachel L. Button appearing there on the screen, marked Rachel Button with the headphones. I can't hear you. I see you nodding your head. Your microphone, you muted yourself there. And now we just lost you. There she is. All right, well, she is appearing on behalf, and she can hear me, right? Okay. We can't hear you, but that's okay. All right, Ms. Button is charged with forgery and theft, 4th and 5th degree felony. This is a Zoom pretrial. Ms. Hapner is appearing on behalf of the defendant, and Ms. Collins appearing on behalf of the state. This is, I believe, a first pretrial.
It's a final pretrial, Your Honor.
Oh, is it? Okay. All right, yes, and trial is set for August the 31st. All right, so where do we stand on this case, counsel?
You know, I spoke with my client a couple weeks ago, and she'd indicated she's going to accept the plea offer by the state. She was expecting to come down here today in person to meet with the probation department and sign the plea form, although it's my understanding she was not able to get down here. So I will get an email address from her and email the form to her and have her send it back, and then we can schedule it for a plea hearing.
All right. All right, thank you. Then, Ms. Button, if you would go ahead and give Ms., well, we can't hear you, so would you go ahead and text or call Ms. Hapner and give her your email address, okay? Thank you.
Thank you.
All right. All right, are you Sally Michelle McKenzie appearing there from the probation department?
Yes, sir.
All right, this is case number 23 CR 109, State of Ohio versus Sally Michelle McKenzie. This is a Zoom pretrial. Ms. McKenzie's appearing from the probation department. Her attorney, Danielle Witt's, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. Defendant's charged with aggravated trafficking and aggravated possession of methamphetamine. This is a final pretrial. I believe the trial date is August 28th. I don't see discovery from the defense. Have you provided your discovery yet, Ms. Witt?
No, I haven't, Your Honor. I believe there is resolution to this case.
Okay.
I just need her to come here and sign this plea offer. I've been trying to get in touch with her for a while now.
All right. Okay, well, Ms. McKenzie, are you over at your office now?
Yes, I am.
All right, well, why don't you go over to her office after you get done? She may have another hearing here, but you can go over and talk to her then and get it signed, and maybe call Ms. Hoyer and get a time set up, Ms. Witt, because as you know, we're really jammed up in this month, and we need to get these things set as quickly as possible. So, although it's probably going to be at the end of next week before I get it in because of the trial next week. So, all right, so Ms. McKenzie, if you would go see your attorney. Thank you.
Okay, thank you, sir.
All right. George?
Yes, sir.
Okay. All right, there you are. Okay. Now I see you. It says Misty Daniels. All right. This is case number 23 CR 93, State of Ohio versus Misty Spring Daniels. You're Misty Spring Daniels, correct?
Yes, sir.
All right. This hearing is being conducted by Zoom. Ms. Daniels is appearing by Zoom. Her attorney is Dennis Kirk, appearing from his office. Appearing on behalf of the state is the prosecutor, Hickok Collins. The defendant is charged with endangering children and aggravated possession of methamphetamine, and the trial date on this is August 31. Today's the final pretrial. Now, I have been presented with a plea of guilty form. Mr. Kirk, do you and your client both agree to her appearing before the court for this plea hearing by Zoom rather than an in-person court appearance?
Yes, Your Honor.
And you're in agreement with that, Ms. Daniels?
Yes, sir.
All right. Now, this agreement, I'm going to hold up to the screen, the camera, and ask you if you can identify that. It has your name, case number, plea of guilty form, and the charge.
Yes, sir.
All right. On page 3, there's a sentence about a quarter of the way down. It says, enter this plea voluntarily. And right below that, a signature, Misty Daniels. I'll hold that up. Is that your signature?
Yes, sir.
And when did you sign this agreement?
Yesterday about 4:30.
All right. And when you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial? And the next step in your case will be a sentencing hearing.
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
And did your attorney go over it with you and explain everything to you before you signed it?
Yes, sir.
Did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
And is this still what you want to do today?
Yes, sir.
Now, the charge says, or the plea form says you're going to withdraw your not guilty plea and plead guilty to the charge of endangering children under 2919.22A of the Ohio Revised Code, a 4-3 felony. Further states you understand that the maximum penalty for that could be 18 months in prison. The minimum will be 6 months if a prison term is imposed. There could be a fine of up to $5,000, and there could also, that's it. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on community control, probation, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you're convicted of this offense and sentenced to prison, once you complete that prison term, it is possible as part of the sentence that the adult parole authority would choose to put you under what's called post-release control supervision for a period of up to 2 years, meaning you would be supervised under the terms that they set by a parole officer. And if during that period of time they determined that you had failed to comply, then they could return you to prison even though you've served the entire term set by the court for an additional period of up to half of your prison term for one or more violations. However, if your violation is a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, I'm not required to sentence people for this offense to prison. I can't impose what's called community control or probation. That means that instead of going to prison, you'll be put under the supervision of a probation officer for a period of up to 5 years on the term set by the court. If during that period of time, the probation department felt that you were non-compliant, they would file a written notice of that with the court, and then you would get a copy. There would be a hearing. If the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control and then sentence you to between 6 and 12 months and fine you, 6 and 18 months, I should say, and fine you $5,000. You understand that?
Yes, sir.
All right. And if I said 12 originally, the maximum is 18 months. The prison is 6 to 18 months is the possible prison term. Now, the charge in count 1 alleges that on or about May 5, 2023 in this county, you did recklessly being the parent, guardian, custodian, person having custody or control, or person the local apprentice of V, a child under the age of 18 years of age to 10 years of age, created substantial risk to the health or safety of said child, of the said V, by violating a duty of care, protection, or support, said Misty Spring Daniels, having previously been convicted of endangering children in Champaign County Common Pleas Court, case number 2016 CR 104 on June 30, 2016, in violation of section 2919.22A. So that's the charge, 4th degree felony with a prison term and fine that I explained to you earlier. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of that charge, the evidence of the case, possible legal issues of the case, a possible defense you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
And on page 2, there's a couple of sentences that are printed in bold and underlined, and it reads, defendant will enter plea of guilty to count 1. State will dismiss count 2. State defense will argue sentencing. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No, sir.
Now, under the law, you have certain constitutional rights you must understand before I can accept your plea. Would you call out the jail and tell him to get the Zachary Harcourt in for this bond review, because Bill's here. Harcourt? Harcourt, yeah, he's not set till 3. Tell him to go ahead and get him in, and I'll do him as soon as I can get him in here. I know, tell him I'm finishing up the plea right now. Okay. All right. Now, Mr. Kirk was appointed not simply to work the case out for you, but to provide any defense that might be available to you under the law. So, if you decided you did not want to do this, that you wanted to defend against the case, then he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have the right to have a trial on this matter in which a jury of 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law, and then that jury would decide whether the state proved your guilt. And all 12 of them would have to agree on that verdict. In the event that you did not want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, would be the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
All right. Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witness against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, you're presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to provide any defense whatsoever. You may, but you're not required to. But whether you do or not, the burden of proof will stay upon the state of Ohio to prove your guilt by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Originally, you entered a plea of not guilty, Ms. Daniel. That plea denied the allegation in the indictment, denied you committed a crime, and it exercised or invoked all the rights I've just described. If you change your plea from not guilty to count one, that's a complete opposite of the not guilty plea. That plea admits the allegation in the indictment, admits the crime that you committed that crime. And that plea waives, gives up all the rights I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But without exception, your plea of guilty waives, gives up your right to have a jury or court trial, waives, gives up your right to confront witnesses and cross-examine them through your attorney, waives, gives up your right to use the power of the court to compel or force witnesses being in court to testify for you, the same as the state. It waives or gives up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. It waives, it gives up your presumption of innocence because if you say you're guilty, that's what's used to find you guilty. And it also subjects you to being sentenced immediately by the court. Finally, it waives, gives up any right to file an appeal you feel you may have had up to this point in the case. Should you be sentenced to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
You have any questions at first?
No, sir.
Okay, so you do understand them.
Mm-hmm.
All right. I didn't say this to you at the beginning, but if you need to speak with your attorney, I can put you and him into a breakout room for you to talk confidentially if you need to do that. Do you need to speak with him about anything?
Could I?
Sure.
No, I don't need to. I don't need to, sir. It's fine.
Okay, all right. Okay, then is it your intention to withdraw your not guilty plea and plead guilty to count one pursuant to the terms of the plea agreement?
Yes, sir.
All right, then as to the charge, which alleges that on or about May 5, 2023 in Highland County, Ohio, you did recklessly being the parent, guardian, custodian, person having custody or control, or person local parentis of V, a child under the age of 18 years of age, to wit 10 years of age, created a substantial risk to the health or safety of the said V by violating a duty of care, protection, or support, and said Misty Spring Daniels having previously been convicted of endangered children in Champaign County Common Pleas Court Case 2016 CR 104 on June 30, 2016, in violation Section 2919.22A of the Ohio Revised Code, the charge of endangering children, 4th degree felony, carrying possible prison term between 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, Mr. Armentrout, if you're there, we're going to do that bond review next on Mr. Harcourt. All right, the court finds on this day in open court, defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. The pleas accepted, order filed. Defendant is found guilty of count 1 as charged. Count 2 is dismissed. The matter is referred to the probation department for a pretrial report, and bond will be continued. We will set the sentencing hearing for September 6.
Your Honor.
Yes.
I'll be out of the office that day.
All right. Are you going to be out that whole week?
Yes.
We'll set it for September the 12th at 2 o'clock in the afternoon. All right. So, Ms. Daniels, you'll need to contact the probation department to arrange for your pre-sentence interview and be in court on that date in person.
Okay.
All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. All right. We'll do
Thank you.
Harcourt next. All right. This is case number 23 CR 128, State of Ohio versus Zachary E. Harcourt. Here's Zachary E. Harcourt appearing there by video from the jail.
Yes, sir.
All right, Mr. Harcourt was arraigned yesterday on a charge of receiving stolen property, 4-3 felony. Mr. Armentrout was appointed to represent him. Since Mr. Armentrout was not present for the hearing, the court set a review of the bond pursuant to, well, it used to be criminal 46, now it's, forget what provision of the revised code in, but it basically is the same as what the former rule was. Bond was set in the amount of $2,500 plus OR. Now, Mr. Armentrout, would you like to speak to the matter of bond?
Wait, Your Honor, I've not had a chance to speak to Zachary. It's I don't know what, thinking about a prior record, it's only a 4th-degree felony. I guess it would appear they failed to appear for a prior hearing.
Yeah, he didn't appear for summons. He didn't appear for the arraignment. So,
I guess if there's no extensive prior record or failures to appear, Your Honor, I would ask the court to consider no R bond in this matter.
all right, Ms. Collins?
Your Honor, he does have a prior record and has previous felony convictions. I'm looking for, I don't see a prior failure to appear.
If Your Honor, if I may
Just
say.
be quiet. Smart.
You don't say anything right now, Zachary.
Prosecutor speaking. Yeah. Anything else you'd like to say, Ms. Collins?
No, Your Honor.
All right. Well, what happened in this case is a summons was issued, and Mr. Harcourt did not appear, and it indicated that he was trying to get into treatment, but he hasn't yet. But in the event that Mr. Harcourt does get into treatment, the court will consider and likely would release him to a treatment facility. But given what he said yesterday, the court didn't see much progress in that regard. And so the probation office, Mr. Arjima, you might ask one of the clinical staff to meet with him to see if he's a candidate and there can be a bed found for him. And if that's the case, Mr. Armentrout, notify Mr. Armentrout, and then Mr. Armentrout can file a motion. At that time, I'll address that issue. But given the fact that he's admitted that he's in need of treatment, he didn't appear for the arraignment in this case, court feels that a bond is necessary to ensure his appearance. So the bond will remain the same. All right, thank you. All right, what is the... All right, this is, let's see, who's her attorney?
Mr. Kirk.
Mr. Kirk, all right. Case number 23, CR 71, State of Ohio versus Pamela S. Lambeth. Ms. Lambeth is appearing on the screen. This is a hearing being conducted by Zoom. She's appearing on the screen marked Sampson SM G98-1V, it looks like. Her attorney is Dennis Kirk, who's appearing from his office, and appearing from the prosecutor's office, Prosecutor Collins. Defendant is charged with unauthorized use of motor vehicle, 5th-degree felony. There has been a motion. Well, first of all, Ms. Collins, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
They have been notified and they will not be attending.
All right. Now, I see there's been a motion filed today for intervention in lieu of conviction, and stipulated questions have been answered. except for those that are not applicable yet, which would be the intervention plan. So the court will order, are you in a treatment yet, Ms. Lambeth?
Not as of yet.
All right. Well, you'll report to the probation department then tomorrow to talk with them about an assessment and a possible course of treatment, and we will set this for a hearing on August the 24th at 2 p.m. All right, so make sure you get into town and talk to them, and then keep in touch with your attorney. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, this is case number 23 CR 120, State of Ohio versus Donald Richard Henson Jr. Are you Donald Richard Henson Jr. appearing there from the probation department?
Yes, sir.
All right. This is a pretrial being conducted by Zoom. Mr. Henson's attorney, James Chandler, is present from his office. Present from the prosecutor's office is Prosecuting Attorney Collins. Defendant is charged with one count of receiving stolen property. Ms. Collins, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing, the right to be heard?
I have, Your Honor, and they are not going to be attending.
All right. All right, now I believe this is a first pretrial, and the matter is set for a final pretrial on the 23rd, and trial date is the 25th. I see that there's been a request for discovery, and the state has provided that. You received that, Mr. Chandler?
Yes, I have, Your Honor.
All right, your discovery is due by the final pretrial. And do you anticipate any pretrial motions?
Not as right now, Your Honor, although I might ask for a continuance in this matter. Mr. Henson's got some medical issues he needs to address, including surgery. And he's also got two other trials pending, one in Ross County and one in Pike County. And I would ask for a couple of months extension if I could, Your Honor.
Mm-hmm. Well, if you want to file the motion along with the reason for the continuance, as far as medical concerned, you know, if you provide the documentation, I'll consider it. As far as the other cases, you know, that's not going to be a continuance in this case. So, if that's the only reason. But if there is a legitimate medical need to do something before the trial that would interfere with that trial date, then certainly the court will give that due consideration. So,
I'll do that, Your Honor.
all right. Any other motion will be due by the final pretrial. Has there been a written plea offer provided yet?
Yes, Your Honor.
Okay.
I've received it also.
Is your client aware of it?
Yes, he is, Your Honor.
All right. All right. Any other matters to discuss then at this time?
No, Your Honor.
All right. Thank you. Michelle Syons. All right. This is case 23 CR 122, State of Ohio versus Michelle Lynn Syons. Are you Michelle Lynn Syons appearing on the screen, Mark George?
Yes, Your Honor.
All right. This is a Zoom pretrial. Ms. Syons' attorney is Dennis Kirk, appearing on from his office, and appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged along with a Jason McCoy in a multi-count indictment. It looks like she's charged in counts 1 and 2, which is aggravated trafficking and possession of meth, and count 5 and 6, which is the same. This is a first pretrial, trial set for October 12, final pretrial September 6. I see that state provided discovery, and Mr. Kirk, your discovery will be due by the final pretrial. And I do see there's a motion to continue the pretrial, but other than that, do you anticipate any pretrial motions?
Not at this time.
Okay. That'll also be due by the final pretrial. And has there been a written plea offer provided?
Yes, Your Honor.
And is the defendant aware of it?
He is.
All right. Now, regarding the 6th of September, since you're going to be out of town, I will go ahead and reschedule that. Let's make that, today's the 2nd, so let's make it August 23rd at 2:30 p.m.
Will that be by Zoom or in person, Your Honor?
That can be by Zoom. All right. Any other matters need to be discussed at this time?
No, Your Honor.
All right. So your next pre-trial date then will be August the 23rd, Ms. Lyons, and we'll send your attorney a link, and he can forward that to you.
All right. Thank you, sir.
Thank you.
Have a great day.
All right.
This is a treatment lab.
Good afternoon.
All right. Good afternoon. Are you Jason Storr there at the probation department?
Yes, sir.
All right. We have two cases involving Mr. Storr. Case number 23 CR 53 and 23 CR 101. This is a Zoom pretrial. As indicated, he's appearing from the probation department. Mr. Storr's attorney is William Ermentrout, appearing from his office, appearing from the prosecutor's office of Prosecutor Collins. In case 23 CR 53, the defendant is charged with breaking, entering, and theft, and in 23 CR 101 with aggravated possession of methamphetamine. Now, with regard to 23 CR 53, Ms. Collins, has the alleged victim been notified of the time, place, and purpose of this hearing?
He has, Your Honor, and he is not in attendance.
All right. All right. This is a final pretrial. We have a trial date set for August the 28th. Looks like discovery has been provided. And where do we stand on this case, counsel?
Mr. Ermentrout's muted.
I filed the application for treatment in lieu today, Your Honor. This was on a fast track because originally he was on bond, but he did make bond, so he's been out. Filed that today along with the questions. The state's recommending it, and he may already have his assessment scheduled.
Oh, I see that. They are in the file. Okay.
I done an assessment yesterday.
All right. Well, then the court will order an intervention assessment and report from the probation. So you'll need to contact probation, Mr. Storr, so they can prepare a report for me. And we will go ahead and set this for a hearing on September 7 at 1 o'clock.
Hold here, if there.
All right. Anything further, counsel?
No, Your Honor.
All right. You'll also need to sign a release for the probation department there, Mr. Storr, but see Mr. Arzima before you leave. Thank you.
Yes, sir. Thank you.
Is he at the probation department?
No, he isn't, Your Honor. I believe he was going to his attorney's.
You believe what?
I thought he was going to his attorney's office for it.
All right. His attorney is Jeff Meadows. and he's not signed on. I see a Lisa Wells connecting the audio that I have admitted that person about 4 times so far today, and they're apparently having computer issues.
Export, click on the phone, and all my other contacts from that over to my Proton Mail.
All right, if you're Mr. Meadows is speaking on the Lisa Wells screen, I could not understand what you're saying, and I cannot see you. So I'll continue this pretrial, and we'll have our next pretrial in person. Don't speak with, do not.
Draft copies in my email folder says I wouldn't lose them.
All right. Now, you're muted, Mr. Meadows. Don't touch your screen. I can't understand what you're saying. I cannot see you. So we are going to continue this pretrial, and you and your client can appear in person. I'm not going to waste a lot of time on trying to figure out the technical problems you're having, because we've been doing this all afternoon. So your pretrial will be set for August the 16th at 2 p.m. in person. And again, I don't know what, I didn't understand anything that you said. I could hear your voice, couldn't see you or understand you, so that's the reason we have to do it this way. All right, that's it, right? All right, that will complete the hearing then. Thank you.